I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you take me?
What do you have in your mouth? What is that?
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you take me to...
What do you have in your mouth? What is that?
So, ladies and gentlemen, how are you tonight, this evening? I'm on late tonight. Usually I'm on during the day, and we tried to do a stream earlier today, and I tried to do it with the bearded fisherman from the Northeast. But we had technical difficulties on my end. This was my fault, or it wasn't my fault, but on my end, there was like an outage for Xfinity. That's like Comcast down here in Southwest Florida. So it was like a huge outage, and like I was off. Like my stuff was like, not on. I couldn't like get on the internet. I was off the internet from like 2:30 when we tried to go on until about 7:30, 8 o'clock at night. So what I did was I figured I talked to Bearded. I said, dude, let's go and try to do something. He's like, I'm tired tonight. I'm like, okay, I'll go on myself and I'll put on like the stuff that I wanted to put out there. And so what I'll do is I'll put out the stuff that we need to put out. Some stuff came down today in the Fed 2 case with Jeremy Hales, and I want everybody to kind of know where we are on that. And then what I'm going to do with Bearded is we're going to do another day, maybe this week, maybe Friday, or maybe like next week, and we'll do like the show that we wanted to do too, because part of what we were going to talk about with Bearded was just like regular stuff, like just normal stuff. We're going to talk about all sorts of different things, because he's up in Connecticut, and he was actually by the spot where he had his motorcycle accident. And so we're going to talk a little bit about that. We'll talk about how he's doing up there. Summertime, he's fishing. He's a happy guy. So we were going to do some of that, which is pretty cool. But we'll do that. We'll do that like either Friday or next week. We're not going to rush it. And he said it. He's like, look, it's just everything happens for a reason. It's on God's time. So we'll get on when we get on. We'll do what we got to do. So I want to start tonight talking a little bit about what happened. And what happened was in the courts right now with Fed 2. We're going to talk some Fed 2, and we're going to talk some Jeremy Hales, what the Hales, Randy Shochet, all the other scumbags related to that. Now, it starts with this guy. I'll put him on the stage here. That's a picture of the guy that is the magistrate judge, and his name is Zachary Bolitho. And Judge Bolitho, he just put an order out about me. And I made an application to the court. And the application to the court, and there's the Bearded. Bearded, what's going on, buddy? I put an application to the court, and I had said, I made a motion to dismiss the case that Jeremy Hales has. And for anybody who doesn't know about this case, a lot of people do know about this case and about Jeremy Hales. Jeremy Hales has a YouTube channel called What the Hales. He's got also other social media platforms and totaling over 1 million followers across all platforms. He basically sells stuff. He does auctions and storage units and everything else. And I'll be the first to admit, his stuff is pretty entertaining when he's doing the storage unit stuff, the hidden treasures type stuff. And if he stuck just to that, it would be, nice. But what he decided to do was he decided to get in on this, bad neighbors type stuff, this Hatfield and McCoy type stuff, the modern day Hatfield and McCoy type stuff using YouTube. And he harassed these two nice people called Michelle Preston and John Cook, who were his neighbors in Otter Creek, Florida. He doesn't live in Otter Creek, Florida as his primary residence. He's actually a carpetbagger from Ohio. And so he carpetbagged down to Otter Creek, and he's harassing these poor people. And he did it just to create YouTube content, because on top of the harassment, he has legal battles. He's probably had 5 or 6 different cases just on this alone. And so what this guy does is he basically creates legal cases and puts them in front of the court. You're insulated by something called litigation privilege at that point. You start talking about what's going on. It's in court. And then he has his whole group called the ecosystem. And what they do is something called polymop, for attraction of litigation and multiplication of proceedings. And what they do is they basically put all this paperwork in, and they start talking about every little piece of paper that comes in. And so from Jeremy, it trickles on down to this woman named Megan Fox, who used to be a journalist and used to actually work with a guy that I do a lot of work with, Michael Volpe. He's my partner on my podcast, The Unknown Podcast. Me and him cover family courts together. And Megan was a good journalist for a long time. She fought for the families. She fought for family court, for the rights, for the people. But I guess she became, well, for lack of a better term, a media whore at a certain point. And if you saw the video that I played on the way in, that video was my satirical representation of her becoming Jeremy Hales's media whore. It was published in January of 2025. And basically, it was done for those satirical purposes. So the crux of the case that we have now left in Fed 2 is a case about 2 things. One, it's Michelle, who's in bankruptcy, and that part's not moving forward. But the part about me, they're claiming that the video you just saw is revenge porn under the Florida law. And so what I've done is today, and we'll see the paperwork very, very shortly, the video you just saw is now a filed court exhibit in Fed 2. It was filed today under docket number 205-1. It's Exhibit A to a motion that I filed, and it was docketed today, and that is now something that is in the court. So to honor that, what we're going to do, and this is the judge that's looking at this stuff, we'll come back to him, but to honor all that, I'm going to play it again. This is, ladies and gentlemen, a newly filed exhibit in Gainesville Federal Court, docket entry 205-1 in Luthmann versus Preston and Hales. Everybody watch.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you take me to...
What do you have in your mouth? What is that?
So that is the newly filed docket in the Fed 2 case, 2005-1. And we're going to show that in a few minutes. But I wanted to show what Monica just said. She said something very important. We started watching for it was entertaining, not malicious. And that was Jeremy Hales. That was also Megan Fox. At a certain point, she used to be a journalist, and she used to cover things that helped people. And also the rest of the ecosystem. Tug, that umbrella guy, he covered stuff like the Amber Heard and Johnny Depp trial that people were, actually wanted to look at. You got Shizzy Wiznut, and you got J Jip, and you got the rest of that bunch. You got Mr. Coop, that moron. You got a whole bunch of just idiots out there. And what happens is, they have this ecosystem, and on my belief, my information and belief is that they use burner phones and they coordinate with each other in order to run smear campaigns and to promote their ecosystem for pecuniary gain. And that's one thing. That's fine. We'll see where that's going to go. But what we're going to talk about today is what the legal papers that are in there and a couple of legal notices that were put out. And so, for those of you who don't know, I'll put some pictures up. That's Jeremy Hales, okay? And he's got, he goes into the storage unit and he finds things like Pez dispensers, and that's a Megan Fox, a Pez dispenser. And so that's Jeremy Hales with the Megan Fox Pez dispenser, okay? And so Megan doesn't like Pez as much as she likes something very, very important to herself, and that's what's called breadsticks. And so when we saw that video before, and I showed this on Lisa Lee's broadcast the other day, that when she disappeared from the frame, because we saw the frame, it was only the very top part of the frame. When she disappears from the frame, she goes down and she starts going for the breadsticks, right? They start going for that. She asks for breadsticks all the time, and she's driven by breadsticks, and that is where her head went down to the breadsticks, to be closest to the thing she loves the most, the breadsticks. On the floor of the car was also Federal Prison Monthly with me, with Paint Chips Rockin' the Conjugals. And that is an excellent, excellent issue of the magazine if you haven't read it yet. It's one of the best. So that's what we have here, and that's the video. Now, if you want to know what happened and we'll get to this, about the revenge porn statute that they're suing under, they said that I had depicted them, Jeremy Hales, in an intimate relationship. He didn't mention Megan Fox. He said with a journalist. And so when we pull back to the full, scene from the car, there were a lot of people in the back seat of the car too. So, when you go to the back seat of the car, you see there was an actual journalist that everybody knows named Don Lemon in the back of the car, the satirical car. And so I'm thinking that maybe Jeremy Hales is admitting that he had oral sex with Don Lemon, the journalist. That's what I'm trying to figure out, because I know that Megan Fox is no longer a journalist. She is a former journalist or a content creator. She's like basically the ecosystem media smear. That's what she does. She's the smear jobber. And so maybe it's Don Lemon, that's the journalist that he's referring to. We're going to get into that in a second, but there's other people there too that we got to know about. But that's what we need to know about this. But we'll go back to this guy right here. That's Bolitho. He's the judge. And so Bolitho put out an order the other day, and Bolitho put out an order. He said, "Who's the guy with no shirt? Which guy with no shirt?" Add this. That is Don Lemon. Don Lemon is a very famous journalist. He used to be on CNN, and he's off CNN. He's the one who was in the church in Minneapolis that they rushed into the church during a service, and he actually got arrested. He was there with all these Antifa people, and he was filming them, and he was one of the people that was arrested for that. And so he's a very famous journalist. And so in the satirical video that I made, in the back seat of that car was Don Lemon, was one of the people there. There was a lot of people there. You see Randy Shochet and Doreen Turner-Angelis and Tug and Squid Pro Quo and this one and Coop and that one. And there's a bunch of them there. So, they were in the car, but Don Lemon was back there. I'm trying to figure out who the journalist is. So, and that's what we're going to do. So let me put this up on the screen now for everyone to see. This is the order that Judge Bolitho, and that's Bolitho again, had put up. Bolitho, there's been, and Mike Volpe from the very beginning is kind of like, this Bolitho guy, he could have done a lot better if he would have just, started ruling on this stuff. It took forever him to rule on things, and he doesn't want to knock things out. But we'll go through this right now. So this is what we got here. This is an order that came down. So it was filed 6-2. It's 6-3 today. So this was filed yesterday. And I know Mr. Coop already had this on his show, and a bunch of them say, Paint Chips got denied again. He was denied by the court and shot down. So What's this all about? Defendant Richard Luthmann moved for leave to reply to a plaintiff's response in opposition to Luthmann's motion to dismiss. So what's this doing? I wanted to dismiss the case against me. Okay, all that's left here is Jeremy Hales and Richard Luthmann, right? And there's Michelle, but that case is against her, stayed because she's in bankruptcy. And everybody else that was part of this, Bruce and Lisa and Robbie Kesey and Ray Bone Crusher and who else? Milltown's Best, Super Dave, and other people. Everybody that was there, Marla, everybody that was in the case, it got dismissed against them because they said there was nothing there. All that's left with me is this claim that I violated somehow the Florida revenge porn statute by putting the stuff together that you just saw, that video, and putting it on the internet in some way. And so it doesn't hold water, and we're going to show you how today. But there's two versions of the statute, and that's what we're going to get into. One version of the statute was the one that was in effect when this was first published, and there's something called the single publication rule. When you publish it once, that's when the publication date is. You published it. And so, and now it's covered by what's called litigation privilege because I'm showing what happens as part of litigation. And this is now, it's actually an official court document. So I can publish this thing and rebroadcast it as many times as I want because it's related to the litigation. And really any claim that they have relates back to the date of the original publication in January of 2025. Well, at that point, you got to understand this, people. On that day, there wasn't an amendment to the statute. They did an amendment later on in October of 2025, last year, to take effect on January 1st of this year, and that was about deepfakes. So you know about deepfakes, like if you're going to do deepfakes and you're going to make it look like it's revenge porn for somebody, then you can actually sue under the statute under the amended version. Like, let's say, they were created. I know Megan Thee Stallion did it. Megan Thee Stallion did the suit under that because somebody had made a deep fake and she actually won. And so, but this case, it's not at that point yet, right? This was before that, and this is a claim that they're saying that I did a deep fake of Jeremy Hales with a journalist, and I got confused. I'm just a simple caveman over here. And I was very, very confused when he put in his opposition. And here's why. I talked about how this wasn't an issue and it should be dismissed. And he starts continuing to talk about deepfakes. And that's not part of the statute that's an issue. So I said to the court, I said, Judge, I want to put in a reply to make it clear to everybody. We're talking about the 2005 law, the one that was on the books on January of 2025, not the new law. And under the new law, I'm not liable either, and it will be dismissed under that law. But I wanted the court to be clear on what law it was applying. Why did I want the court to be clear? Because a stitch in time helps save nine, right? If the court does not, apply the right law, what happens? Rich Luthmann files a motion for reconsideration. Rich Luthmann files a notice of appeal. This all comes also, it's a mess. There's a procedural problem. And the law says, it's a big issue. It becomes a big issue. So I want to show this to everybody. This is what Judge Bolitho said when I asked for it. I'll blow this up a little bit. Say, a party ordinarily may not file a reply memorandum in support of a motion. That's right. That's true. It says only in extraordinary circumstances may the court grant leave to file a reply memorandum. Okay, that's true. The court finds no extraordinary circumstances here. Defendant Luthmann's motion to reply will be denied. What does that mean? He says that there's no extraordinary circumstances. He doesn't say, how he finds this. He doesn't say any facts. But in so doing, what Judge Bolitho has just ruled, right, Judge Zachary C. Bolitho, is that the judge's time is not extraordinary. That's what they've done. And I'm going to show you how. He just basically ruled that it's not extraordinary. The judge's time, it can be wasted. He's basically inviting people to waste the court's time. The courts have scarce judicial resources. They only have so much, and there are two rules. There's Rule 1 of the Federal Rules of Civil Procedure, and there's Rule 83 of the Federal Rules of Civil Procedure. Rule 1 says, we want just and speedy cases, and we want to preserve the scarce judicial resources. And Rule 83 says when you do a local rule, like he just has over here, Northern District of Florida Local Rule 7.1, then you can't apply the local rule and make it more powerful than the federal rule. And so I'll show everybody what I did, and what I did is what's a lot of fun. So before this happens, this is what I filed a while ago. This is April 28th of 2026. It's over a month ago. And I filed this in the case. And this was my non-consent to magistrate judge jurisdiction. So I didn't want Bolitho, make it nice and big. There we go. Oop. I didn't want Bolitho, to be ruling on stuff he shouldn't rule on anyway. The judge basically says that the rule says the judge can only rule on non-ministerial matter or ministerial matters, non-dispositive matters, things that aren't going to be for the whole of the case. But if you look at what my motion was, right? If you look at what my motion was, it's a motion to dismiss, right? So if they're not going to put in a reply on my motion to dismiss, that goes to the heart of a case being dismissed, right? That goes to the heart of my case being dismissed. Bolitho should not have even ruled on this, right? He shouldn't have touched this because he's a magistrate judge. And I already said to them, look, I don't want the magistrate judge to go in there and handle this part of the case, anything that could be dispositive on the case, right? And so I said it right here. Defendant insists that any dispositive ruling, including motions affecting jurisdiction, dismissal, or final adjudication, be made by an Article III judge. That's my right. That's any litigant's right under the Constitution. You can have, the magistrate come in and do, appropriate pretrial matters, reports and recommendations, all that other stuff. But when it comes to the dispositive stuff, they can't do this. And I sent this on April 27th. It was filed with the court. Everybody has this. You see, there's the filing there. It's in the court's docket. And that's the problem here. This guy is ruling where he shouldn't rule. And when I put my motion in for reply, here's my motion for reply that I had put in, on the 1st. He said that there's no basis here for this thing to get, extraordinary circumstances. Well, it's on the docket. I'm not going to bore everybody because I'm going to show you my objections in a second. But it says it right here in there why this is important, right? And I said it right here because, oh, it's a certification. Where is this? Here we go. The timing issue is therefore dispositive or at a minimum important enough that a short reply will assist the court and avoid legal error, reconsideration, motion practice, or appeal on an avoidable statutory issue. That's the point. This is an avoidable issue. Let's say the court goes and they dismiss the case against me, but they apply the later version of the statute. I would still do a motion for reconsideration, and I would do an appeal even if I won. Why? Because I want the court to get it right. I have an obligation, or they have an obligation to get it right. So I wanted to bring the court and help them to let them know, look, 784.049, that's the revenge porn statute that they're claiming. Well, there's two versions of the statute, the January 2025 publication, the 2024 version, and then there was a later one of October 1st, 2025, right? He didn't want to even get into that, Bolitho. And the biggest problem that he has is right here. I talk about the statutes and everything else, and that it's in place. But, and I talk about the problem with it. But here's the big issue right here. Let's see. Okay, this is about the statutory issues, futility. Okay, I talked about this on Lisa Lee, actually, on the other night. So if you want, go back to her live, and we talked about the sexually explicit image, everything else. We talked about this a lot the other night on Sunday for Lisa. If you want to see what this is about, go back to that. I don't want to bore everybody. But here's what we're going to go back to. This is my Rule 72 objection. See that there's no stamp on the top of this? This was already mailed to the court, FedEx, and it should be there tomorrow. So this is an advanced copy. This is breaking news. This is going to get onto the docket tomorrow. Okay. And so this is my objection to that order by Bolitho. Okay. And Bolitho basically came in there and he said that I can't get my reply. And I'm objecting to him. When I object under Rule 72A, I go up to the Article 3 judge. And Marla has it right. See, I'm going to put Marla up there. Article 3 judges are federal judges in the United States who are nominated by the president, confirmed by the U.S. Senate, and serve lifetime appointments under Article 3 of the U.S. Constitution. Yeah, so there's only, like, they're a constitutional office holder. You have a right to have a Article 3 judge look at your case and dismiss your case or confirm your case. You know, at the end of the day, an Article 3 judge has to say. You can't have some hack off the street. You know, they can't wave a magic wand and replace the presidential appointment and the Senate process of confirmation. It's the checks and balances in the Constitution. You have three different branches of government. You have the legislative, you have the executive, and you have the judiciary. And that's how our government works. You just can't bring somebody in and get rid of that. Okay? So let's see. Oh, here we go. This is a good one, Lisa. Megan is an absolute moron, in my opinion. Actually, Megan is an absolute moron in reality. I think that she has, in my opinion, too. I think that she has mental disease and defect in her mind. She's like a retard. I think that moron and retard's pretty good. All right, so let's go back to this. Defendant Richard Luthmann's objections. Okay, so this is what's been filed. I'll make it a little bit bigger. Here we go. And so this is to the June 2nd order. That's the order we saw, the one-page order. All right, and I'll read some of this. Richard Luthmann, appearing pro se, especially without waiving any preserved defense, objects under Rule 72A to the June 2nd, 2026 order denying defendant's motion of leave to file a limited reply. So I wanted to file the reply, right? What does the rule say? The rule on 72 that I'm saying is that the district judge, the Article 3 judge, must consider timely objections and modify or set aside any part of the order that's clearly erroneous or contrary to law. So that's the standard. What am I asking for? Very, very simple. This is a simple thing. The court should set aside Doc 204, deem the proposed limited reply attached to Doc 203 filed nunc-pro-tunc as of June 1st, and then, consider the reply. What did the reply say? There's two versions of the statute, 2004 and 2005 amendment. Do the 2004 because that was what was in place when the purported video that was, they say it was in their pleadings. That's when it came out, according to them. Alternatively, the court should grant leave nunc-pro-tunc to file that reply, and if the court wishes, allow plaintiff a short surreply, limit the same issue. Meaning, I'm not trying to hide the ball here, and I'm not trying to ambush Germ and Pocket Rocket Shochet. If they want to put in paperwork after this and to argue, why they think they're right, they're not right, they're wrong. But if they want to argue why they think they're right, okay, I don't have no problem with them doing that, but they're 100% wrong. But the fact is, I'll let them put in any more paperwork that they want. And half of this is that I really don't care about how much paperwork goes in here, because every time a new piece of paper goes into the court, Germ is paying for it. I really don't hate Randy Shochet. If I have my way and this case keeps going and going and going and we have a lot more fun, I'm going to make Randy Shochet between $500,000 and $1 million over the next 12 months. Just for all the stuff that we're going to be doing, all the stuff he's going to have to do for the Germ. It's going to be a lot of fun, actually. He's never been in scorched earth litigation before, Jeremy Hales. What he's done is he's launched the cases like a missile himself, and he thinks that he's going to destroy everybody else. But this is now actually going to get fun. Now he's in a prize fight. He's in a fucking prize fight right now, and I am going to beat the shit out of him. He's going to get into the octagon. He's not going to be able to leave. His only way out, hopefully for him, is if this motion to dismiss goes through and the case gets chucked. But I hope it doesn't, actually, to tell you the truth. I think that this is going to go to discovery. And the more that these judges hate me, I think that the more likely they are going to pull me into discovery, and I'm going to be able to have my fun with Germ. Because think about it, at the end of the day, it's not punishment for me to be in this case. It gives me something to do. They don't understand that. That's the thing. What else am I doing here? I'm sitting around and I'm having fun with the Germ. So here we go. No local rule certification required. Yeah, they have this whole certification thing where you have to certify that you tried to meet and confer. When you have an objection, which this is, you don't even have to do anything. And I talked about I did all this meet and confer, and I tried to talk to Shochet and blah, 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 but you don't need that for this. Now, here's the memorandum of law. Here's what we're going to do. The challenged order, that's Bolitho's order, is a one-sentence ruling stating only that because the court found no extraordinary circumstances, defendant's motion for leave to reply would be denied. On this record, that ruling should be modified or set aside for 4 principal reasons. So I got 4 good reasons why this thing gets thrown out. Number 1, first, the order is contrary to law because it applies Northern District of Florida Rule 7.1I without construing that rule consistently with Federal Rules of Civil Procedure 1 and 83. Remember I said before the Federal Rules of Civil Procedure? Well, the Federal Rules of Civil Procedure come from Congress, right? Congress passed the Federal Rules of Civil Procedure, and the president signed them into law. And the judiciary is bound by the Constitution to apply them. It is the most powerful thing that you can have. It's a statutory enactment, aside from the Constitution itself and the Bill of Rights and any of the amendments to the Constitution. So when you have a statutory enactment, they have to follow that. This Northern District of Florida Local Rule 7.1 was adopted by the judges. The judges made the rules. So the judiciary branch only made the rule, the local rule. So that's not as powerful as something that was created by Congress, right? Put on the president's desk, signed into law by the president. That must be followed by the judiciary. And that's the point here. Rule 1 of the federal rules requires that the rules, quote, be construed, administered, and employed by the court and the parties to secure the just, speedy, and inexpensive determination of every action and proceeding, right? Likewise, Rule 83A1 provides that a local rule must be consistent with the federal rules. That's what I just said, federalism, separation of powers. The fact that we have 3 branches of government. The legislature, the Congress makes the laws, the president signs them into effect, and the judiciary interprets them. A court abuses its discretion when it applies the wrong legal standard, follows improper procedures, or makes a clear error in judgment. And then district courts, they have substantial discretion in applying local rules, right? And they have every right to do their local rules, but that discretion must still be exercised consistent with the federal rules and with reasoned case management. And that's the 11th Circuit. That's the bosses of Bolitho and Hinkle. Hinkle's the Article 3 judge. That's the bosses of those people. That's the appellate court above them, right? So they didn't apply the law the right way. And here's how. Second, we show how. Extraordinary circumstances existed here. Defendant's proposed reply was confined to one narrow threshold issue. Which version of Florida Statute 784-041 governs count 2? Right? That's the point. That's the ball game here. Doc 203 expressly stated the proposed reply did not raise new grounds for dismissal, said it sought to address a very specific legal ambiguity that in defendant's view, plaintiff's opposition did not squarely resolve, namely, whether the court should analyze count 2 under the statute in effect at the time of the alleged 2025 publication or under later amendments that became effective October 1st. That's not a collateral point. It goes to the governing substantive law for count 2. Why is this important? Because under the old statute, and this is what Jeremy's going to lose, under the old statute, January 2025, the statute in effect, there's no, AI created simulation, deep fake portion of the statute. You need to have a video. We talked about this on Lisa's on Sunday. You need to have a video that somebody had a reasonable expectation of privacy in. It basically had to have been Jeremy's own video, right? It has to be Jeremy's own video of him having intimate relations with somebody, and it was released on the internet without his consent, right? So they got a problem there because if you're going to talk about deep fakes, and they talk about it all throughout their complaint, and simulated and Hitler mustache and this and that, blah, 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 you can't bring it under the old statute. You can only bring it under the new statute. And so my point basically kills us at the very beginning. I'm saying, look, what are we doing here? Let's talk about what the real law is, not waste everybody's time. And what they want to do, and what Bolitho wants to do, is waste everybody's time, I guess, because that's how his ruling is. His ruling favors the wasting of time and the wasting of the court's time. What he's saying is that the court's time is not extraordinary. The court's time is very, very ordinary. So Judge Hinkle's time is ordinary, and Judge Bolitho's time is ordinary. They're just ordinary people, and their time is ordinary. They're just like any other, Tom, Dick, and Harry out there. It doesn't matter that a federal judge has time. Their time is ordinary. That's what the ruling said, if you really read it. Federal courts sitting in diversity must apply state substantive law. So this is Erie versus Tompkins. So if anybody ever went to law school, and I do not recommend you ever do it, but if you do go to law school, you're going to go to civil procedure, and you're going to sit there, and you're going to wonder what the hell's going on. And the first case that you do is a case called Penoyer v. Neff. And then the next case you do is International Shoe v. Washington. And then like about 2 weeks later, when your head's spinning, they start talking about this case named Erie, right? The Erie Doctrine. This is a very famous doctrine for all the law nerds. And what the Erie case does is it says that when you have a diversity case, what does diversity mean? Diversity is what we got. Germ lives in Ohio. He's an Ohio carpetbagger. He's coming to Florida Federal Court claiming that he lives in another state from the defendant, Rich Luthmann, and $75,000 or more is at risk or at stake. So that gets him into the court under what's called diversity jurisdiction. Federal courts sitting in diversity must apply state substantive law. So the question becomes, if you're in federal court, do you apply federal law in federal court, or do you apply state law in federal court? And the federal courts came up with, if you're sitting in diversity, then you apply state substantive law. If you're sitting in under federal question jurisdiction, that's the other type of jurisdiction, federal question. If you're there for a federal question reason, then they apply their own law, federal law. And there's only three real types of, there's several types. It's ABC, admiralty, bankruptcy, and copyright. Those are the three major bodies of federal law: admiralty, bankruptcy, copyright. Immigration is under there too, but that's all stuff that falls under the federal constitution and federal statutes. So the immigration is really under the Constitution and the statutes there. You have other stuff that's there: civil rights law, Section 1983, civil rights claims. So the bottom line for everybody, right, is that they have to apply Florida law. And the Florida state law that's in effect, they have to apply the proper law. That's what the Erie Doctrine says. Apply the proper law. And so, Bolitho's like, I don't know if you got to apply the proper law. It's a little nuts. So that's all stuff on Erie. A brief reply addressing the threshold issue would have assisted the court in applying the correct law before ruling on count 2. So I'm just saying, guys, apply the correct law. I just want to tell you, like, there's two choices. Don't make the stupid choice. Now the Bolitho's like, nah, we got this. We got this. So all right, we'll see. Third, allowing a limited reply would have promoted, not impaired, judicial efficiency. Well, that's the whole point here. This is where I'm going to win, in that the limited reply promotes judicial efficiency, right? The 11th Circuit, that's the bosses, have repeatedly emphasized the importance of addressing threshold legal defects early to avoid needless expense and wasted procedure. That's a very, very important point. If the Jeremy Hales stuff with the anti-Hales ecosystem, the crazy conspiracy, would have been addressed early on as a threshold legal defect, early, there would have been no expense and no wasted procedure. This docket is on 200 already. Okay, and Bolitho, I think, is remiss. He has been deficient in this point. This is Chadasama versus Mazda Motor Corp. It's an 11th Circuit case. This is where I believe Bolitho is deficient, in that he does not like to address threshold legal defects early to avoid needless expense and wasted procedures. Right? So I think Lisa would agree with me there, right? Lisa, I think that Bolitho could have dealt with Fed 2 pretty quickly and swiftly, and it wouldn't have been a problem. But look what he does. He doesn't do that. He does not do that. So, and we are where we are now. Okay. Where are we now here? Third, Okay, judicial efficiency. It simply warned avoidable procedural imprecision and overbroad litigation practice burden parties and consume scarce judicial resources. That same logic applies. A short, focused reply on a potentially dispositive statutory version issue is more efficient than later motion practice for reconsideration, supplementary briefing after a mistaken ruling, or an appeal on an avoidable issue. Well, we've already got the Rule 72 objection. We have the motion to dismiss. If the motion to dismiss applies to the wrong law, I'm going to do a motion for reconsideration. I'm also going to be doing appeal. You know that Shochet is going to reply. There's going to be opposition. There's going to be motions going back and forth. There's going to be 5 or 6 or 7 or 8 or 10 more pieces of paper. So that's the thing. The local rules themselves confirm this functional point. Local Rule 56(1)D permits a reply memorandum on summary judgment and says that the moving party should do so only when the opposing memorandum raised new matters not addressed in the opening memorandum. Although this case does not involve Rule 56, that local rule structure reflects a common sense understanding that replies are especially useful when an opposition brief introduces or sharpens a matter requiring a focused response. The proposed replies served precisely that function. I'm telling the judge, just don't mess up. Don't use the wrong rule. There's 2 rules that they want you to use the rule, but that rule doesn't apply because the video is from January 2025. They're trying to trick you. Don't get tricked. That's all I'm telling. I'm trying to help the judge out. I'm trying to do this guy a favor, but they don't want the help, I guess. Fourth, the record before the court made the extraordinary nature of the request plain. The proposed reply was already attached, so its scope and modest size were immediately evident. Doc 203 showed defendant had first attempted to eliminate dispute by seeking a stipulation from plaintiff before filing. The motion thus presented a narrow, non-prejudicial request aimed at avoiding error and conserving judicial resources. The court's order did not address any of those circumstances. On this record, the conclusion that there were no extraordinary circumstances was clearly erroneous, or at minimum, contrary to law. So I think that's going to carry the day. I should hope it does, because if the judge's time is only ordinary, then saving the judge's time is not an extraordinary circumstance. Think about that. Why did you file this, Mr. Luthmann? I filed this to save the judge's time, so they didn't have to waste their time doing something to help the judges out. Oh, no, Mr. Luthmann, the judges are only ordinary. Their time is only ordinary. Therefore, we cannot take the reply because the judges are not extraordinary. They're just ordinary. Their time is ordinary. They are ordinary. They're not extraordinary. You can't save them time. You can't even try to save them time because they're ordinary. That's what Judge Bolitho's order says. So it is what it is. So that's the point that we have here. And I talk a little bit about my pro se status because I am pro se, and we'll see what they say about that, because I have a judge, he's dead now, Jack Weinstein, who says I'm too batshit crazy to be construed to somebody that can be learned in the law. So I like to litigate that one too. That's a fun one. So that's what I put in. I told them to put all this stuff. That's the next one. That's where we are there. So I'm going to take a break for a second, and we'll pull the stuff down off the screen. And I will tell everybody that we're going to show everybody the newly filed exhibit 205-1 in Federal 2. There's a brand new exhibit that got filed with the court today. It was docketed. It's there in the court. And I'm going to show it to everybody right now.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you take
What do you have in your mouth? What is that?
So that's the newly filed exhibit in federal court. That is the video at issue that they claim is somehow a revenge porn. And we know for a fact that it's not, because what she was doing was nothing pornographic in any way, shape, or form. And she was going after her breadsticks. That's what Megan does. She goes after breadsticks. That's what the girl does. And she eats the breadsticks. That's what she likes. She wants breadsticks and breadsticks. Rah, 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 rah. Breadsticks. She's Piglet. That's what Piglet does. So we're going to go to the next little piece. And the next piece that we have is, let's put this down. Let's see. How do we do this now? We're going to take the breadsticks off the stage. I'm going to put this. Okay, this is what we just talked about. And then we're going to talk about the next piece. And let's see. This is, oh, I'm going to go back up because this is what got filed, ladies and gentlemen, today in the federal court. This is brand new breaking news in the federal court in the Northern District of Florida, Gainesville Division. And I filed a motion. Now, everybody's got to understand this motion. Jeremy Hales has, since the second amended complaint, I believe, in this case, or maybe the first amended complaint, whatever I got in, he claimed that there was revenge porn that I had created about him and another journalist. And he's used that language several times. He used that in the third amended complaint, and he used that in the opposition to the motion to dismiss that he filed, that there was revenge porn with him and another journalist. And in claiming that, my claim is that Jeremy Hales has committed perjury, and he's committed misrepresentations before the court, or fraud on the court, and that Randy Shochet, his lawyer, has also aided and abetted that fraud on the court. He's committed fraud on the court too. And Shochet's almost worse, in my opinion, because Shochet should know what the law is and know that the law that he's claiming doesn't apply, and that the claim of having some type of revenge porn, he would have to have some type of reasonable expectation of privacy, and none of that exists. So the statements that he's making are perjurous statements. They're actually, if they're perjurous, they're felonious too, potentially in the federal court, potentially felonious. That means felony statements. So they could be subject to prosecution. And that's the problem that we have here. So let's start reading some of this, because this is some juicy, juicy stuff. Defendant Richard Luthmann, appearing pro se special without waiving any preserved defense, moves for an order requiring plaintiff Jeremy B. Hales and plaintiff's counsel Randall Mark Shochet to show cause why sanctions and other relief should not issue based on repeated factual representations to the court that the challenged media, that's the media we just watched, quote, depicts plaintiff engaging in oral sex with a journalist, when the media itself attached as Exhibit A. That video is now Exhibit A in the federal court. Do not do so. This motion is brought under the court's inherent authority, 28 U.S.C. 1927, as to counsel, and local rule 11.1, and alternatively requests that the court issue its own order to show cause, and they can do that under Rule 11. This motion is not a party-filed Rule 11C2 sanctions motion. It does not seek to bypass Rule 11 safe harbor requirements. This is not a party motion. I'm asking the court to do this on its own. And that I conferred in good faith with Randy Shochet, and I'll show the email in a second. And here's the relief that I want. This is what I want the judge to do. Order Hales and Shochet to show cause within a time set by the court why sanctions and other relief should not issue for repeatedly representing that the challenged media depicts plaintiff engaging in oral sex with a journalist. So what am I asking? I'm asking for the judge to call in Randy Shochet and Jeremy Hales and bring them into the court and have them show why they shouldn't be punished for making the statement that the plaintiff is engaged in oral sex with a journalist. So they have a couple of choices. They can say, well, no, the plaintiff really was engaged in oral sex with a journalist. That's what the video shows. I don't think that's going to work. You know, let's take a poll out there. Do the people out there think that if Jeremy goes and plays that video in court, the judge is going to think that that's a video of him having oral sex with a journalist? Or do you think that the judge is going to say, Jeremy, Randy, what the hell are you doing in my court with this piece of crap? Get the hell out of here. and here's some sanctions on the way out. What do people think? A, that the judge is going to say this is oral sex with a journalist, or B, you guys are terrible, terrible, terrible people. Get the hell out of here. I think that the judge is going to go with B. That's my gut. That's really the relief I wanted this. I want the judge to say that this is very, very terrible. B, require plaintiff and counsel to lodge, under seal if necessary, the exact media they contend supports that allegation and to identify the exact frames, still images, or timestamps on which they reply. So, what do I want? If there's oral sex with a journalist in that video, tell me what frame, show me the still images, and tell me the timestamps in that video where that oral sex with a journalist is. Right? That is not an unreasonable request, right? They're suing me. He says he wants $370-something thousand, right? Well, I got some people think it's B. B, Monica thinks it's B. Bruce thinks B for Bruce, right? Sylvia says C. Let's see, Sylvie. We got B over here, B, right? A lot of B's I got going here. I think B's the good word. But it's not a hard thing to ask people, right? You know, you're in court, and so, you know, you got to be particular, right? There's something called a bill of particulars. That's one of the discovery pleadings, right? And so you could particularize. Tell me specifically, Jeremy, what portion of that video, we've distilled the video that you've claimed is the problem. That that video entitles you to $375,000 or something like that. That's what you want. So isn't it reasonable for us to ask you what frames in that video, show us the still images, show us the timestamps. It's a 1 minute long video. At what second or what seconds is there oral sex with a journalist? Right? I still don't see it. I don't think anybody here could see it, you know, because it doesn't exist. And what that means is that they're making representations to the court that it does exist. And it's not just a situation of mistaken belief, right? Nobody who looks at that video could say that there's a frame, a still image, or a timestamp where there is Jeremy Hales, the plaintiff, engaging in oral sex with a journalist, right? They don't even identify the journalist. So I don't know if it's Don Lemon. I don't know who it is that he's engaging with. It could be Peter Jennings' corpse. Who friggin' knows? You know, we don't know who the journalist is because he doesn't identify the journalist, right? So, and in oral sex, I don't see oral sex. I don't see it. I don't see a journalist, and I don't see oral sex. So, strike, disregard, or require correction of the challenge factual representation ECF number 189, right? 45 and 80, and ECF number 2002 at pages 1, 4, 14, 15, to the extent the court finds those representations are contradicted by the exhibit itself. What's ECF number 189? That is the third amended complaint, right? That's the third amended complaint. No, this is a very good question, actually. Where did 365,000 come from? Why that number? That's the number that Jeremy put in his pleadings. He said like $370,000. That's the damages that he's claiming. He said that himself. This is his own words. I am taking Jeremy's words as the plaintiff, and I'm holding him up to his proofs. That I'm entitled to do that as the defendant. And that's the problem that he's got, is that his words are all bullshit. And so when your words are bullshit and I bring the receipts, in federal court, you get problems, Jerm. You got big problems. So 189 is the third amended complaint, right? Paragraph 45 and 80 are the necessary portions of the complaint that says that this is revenge porn. This is a video. This is, you know, the plaintiff engaging in oral sex with a journalist. Those parts go out. If those parts go out of the third amended complaint, the whole second claim against me fails. Additionally, pages 1, 4, 14, and 15 in the opposition. 202 is the opposition to my motion to dismiss. If those get cut out of the 1, 4, 14, and 15, then his opposition fails and my motion to dismiss carries the day substantively, meaning that he's done. Okay, let's see what we got next. We have D, Award defendant the excess fees, costs, and expenses caused by the repeated accuracy of the challenge factual assertion as permitted by 28 U.S.C. 1927, the court's inherent authority. I'll ask the court for a bill of costs. I had to do some mailings. I had to do some other stuff. Maybe I'll send the judge a very, very specific number. I'll tell him, Judge, I want Jeremy Hales to pay me $69.69. Cashier's check, signed by Jeremy Hales or something like that. And Shochet too. Make him sign it both. And then I'll frame it and put it on my wall. So $69.69 from the two of them. That's what I would want out of that. And then the next part is the big one. Consider whether counsel's conduct warrants discipline or referral under the Northern District of Florida Local Rule 11.1 G. That means that he could be referred to the Florida bar for discipline. Think about that. He would be referred to the Florida bar because of this dishonesty. He lied to the federal court knowing full well that he didn't have anything here, that this was a pile of garbage. And Rule 11 sanctions would be very, very bad for him. And he would be sanctioned and it would be sent to the bar to see if there should be further discipline. And we're going to get to some other stuff here today about that. Now, here we go. This is the fun stuff. This is all Jeremy's stuff. This is what Jeremy said. The operative third amended complaint alleges that in 2025, Luthmann posted a video online depicting plaintiff as Adolf Hitler by adding a Hitler mustache to plaintiff's photograph and engaging in oral sex with a journalist. ECF 18940. That's the third amended complaint. Count 2 then repeats the point more directly. In 2025, Luthmann posted a video online depicting plaintiff as engaging in oral sex with a journalist. On May 28, 2026, plaintiff and counsel repeated the allegation in their response to defendant's motion to dismiss. The response opens by accusing defendant of seeking to evade accountability for, quote, publishing a sexually explicit video depicting plaintiff Jeremy Hales engaging in oral sex with a journalist. Again, ladies and gentlemen that are watching this, was there anywhere in that video where you saw Jeremy Hales engaging in oral sex with a journalist? Was there a single frame, a still, a timestamp that anybody can point to? I'm asking you now, honestly and earnestly, if you can tell me where it is that happened, I will listen to you. I actually, it's something I would love to see. I'd love to discuss that. I'd love to debate that. Is there any place there? Any place there? I don't think so. So it was Germ's imagination. That's probably true. Maybe Germ could say that he's crazy, that he has a crazy imagination. Absolutely not. Marla 6969. That's a good number, right, Marla? Pretty damn good number, right? Monica says no, not at all. Lisa says nope, nope, nope. Like look, this is my jury right here. It's like if I don't need to even get to a jury, because if I get to a jury with Germ, I'm going to win because I have all these counterclaims. Sylvie says no. It's like I'm going to win. I'm going to win the jury. But I don't even need a jury at this point. I thought the video was banned on YouTube. That's right. Well, now it's a filed court document, right? So I don't know how they can be banned on YouTube if it's a filed court document accepted for filing by the federal court clerk. So. We'll see. And at this point, you make a very good point, Lisa. I think we need to play the video again to remind everybody this new filed court document, 205-1 in the Gainesville Federal Court. I want to make sure everybody understands what we're talking about here, the basis of the lawsuit.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me. So I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money.
What do you have in your mouth? What is that?
So that's the video. That's the exhibit that we're talking about. And so let's go back to reading this. I'll make it a little bit bigger for everybody. That's better. That's a little better, right? Okay. They repeated the allegation in the motion to dismiss. The response says plaintiff, the defendant seeking to evade accountability for publishing a sexually explicit video depicting plaintiff Jeremy B. Hales engaging in oral sex with a journalist. The response repeats the same description in its statement of facts at page 4. It then argues that, quote, an edited image that falsely depicts plaintiff engaging in oral sex is still an image depicting a person engaged in sexual conduct. Okay. I don't understand where the sexual conduct is, and that's why we're going to have to look at this video, right? And again, asserts the complaint alleges a video depicting plaintiff engaging in oral sex with a journalist. It's like, this is the nothing burger. This is the nothing burger. It's not even here. Show me what frame it is. Let's cut this case off at the very beginning. Jeremy and Randy, show us what timestamp, what frames, what portions of the video, oral sex with a journalist. Jeremy Hales, oral sex with a journalist. Those are not stray adjectives. They're the factual core of count 2 brought under Florida Statute 784-49 and the centerpiece of plaintiff's opposition to dismissal. That's what he's opposing. He's opposing dismissal. And I said this very clearly that there's two versions right here. I state it again. I cite the cases, right? And that the most important portion of that is that in the then existing requirement, right, the publication of the quote-unquote sexually explicit image must be made contrary to the depicted person's reasonable expectation that the image would remain private. So that's the language in the statute, and he has to say that this video depicting plaintiff engaged in oral sex with a journalist was a private video. It'll be hard for him to claim that it was a private video because I made the fucking thing. All right? It is satire. And so here we have it. This is, Megan could cry her eyes out. This page 14, document 205, this is where I announced to Megan, so the Piglet can cry. Defendant attaches as Exhibit A, the challenge media also identified in the pleadings. This is the pleadings. This is what Jeremy said this. Jeremy points to this link, Luthmann.substack.com, and points to this link. This is from Jeremy's third amended complaint. And I submitted that, all right? And I authenticate the exhibit, right? And it's included as Exhibit A. Right now, there's a flash drive in the Gainesville Federal Court clerk's office with this video on it in raw form that the judge can look at, and go through the frames and go through the stills and figure out if that has any type of Jeremy Hales having sex with a journalist in it. Okay. The defendant submits the accompanying declaration authenticating the exhibit. The cited filings. The point is objective, narrow, and suitable for direct judicial inspection. Whether the challenged media actually depicts what plaintiff and counsel repeatedly told the court it depicts. So I think that they're between a bit of a rock and a hard place. I don't know. What does the audience think? Do you think that Jeremy might have a problem and that Randy, the rocket shocket, might have a problem trying to tell the court that what they told them before and what they've told them before on multiple occasions is really true? I think there's going to be a problem here. It's going to be a big, big problem for them. It's going to be just big problems. So let's read some more about the argument. The court may inspect the challenge media because it's central to count 2 and its contents are the dispute. Well, this is right. A court need not accept the pleading's characterization of an exhibit when the exhibit itself is before the court and is central to the claim. This is the case. Hoffling versus City of Miami, right? That's an 11th Circuit case. Also, Griffin Industries versus Irvin. When the video evidence flatly contradicts a litigant's characterization of events, a court need not credit the contradicted version. That's Scott v. Harris. That is the United States Supreme Court. That means that, Jeremy can say anything he wants, but if the judge looks at the evidence, the judge can say, no, that's not true. Let's get rid of this case because it's BS. That principle fits this dispute exactly. Count 2 depends on the contents of the challenged media. Plaintiff and counsel has described that content in precise visual terms. If those terms are inaccurate, the inaccuracy is material and can be established by the exhibit itself. Next point, repeated advocacy of a material factual assertion without evidentiary support warrants a show cause process. That's what I'm asking for, a show cause process. I might have to drive up to Gainesville Federal Court. They might actually hold a hearing on this issue. That's kind of what I want. I want them to do a show cause and hold a hearing on the issue. I might get a chance to cross-examine whoever they put on the stand, and Jeremy Hales probably, because if it's a show cause for Jeremy and for Shochet, I get to put them both on the stand, and it ain't no fun when the rabbit's got the gun. That's going to be a hard day for Jeremy Hales and Randy Shochet if the judge orders Luthmann to go up to the court and cross-examine Jeremy Hales and Randy Shochet. So everybody, please take notice of this, because this is something that could happen with a show cause process. What I'm asking for them is to hold a hearing, a show cause hearing. They get to present their evidence as to why they think that they're right, and I get to cross-examine them. And when I get to cross-examine them, I have unlimited ability to question them on their truthfulness. And Bruce can back me up on this. Your truthfulness, your credibility is always, at all times, an evidentiary issue under the federal rules of evidence. You may test credibility at any time. So there might be some relevant issues to the case, and there might be issues about relevance and irrelevance about factual issues of the case. But I can always bring up an issue about credibility. So that is going to be a very fun thing potentially for me. So that's what we're working towards. So let's see. What Rule 11 applies when a party or attorney signs, files, submits, or later advocates a paper. Among other things, it certifies that factual contentions have evidentiary support. In the 11th Circuit, the Rule 11 inquiry asks whether the position is objectively frivolous, and if so, whether the signer should have been aware of the fact. That's the test. Whether the position is objectively frivolous, and whether the signer should have been aware of the fact. So you would think that they've identified the video, right? But they can't identify which portions of the video, what timestamp, what frames are actionable, which ones are Jeremy Hales, the plaintiff, engaged in oral sex with a journalist. They haven't identified the journalist. You don't know if it's Don Lemon. I'm thinking it might be Don Lemon. And they're not saying under the statute as well what the reasonable expectation of privacy they have. But it doesn't even get to that point. Show us oral sex with a journalist. Show us oral sex in there at all in that video. Sanctions may follow when counsel fails to make a reasonable factual inquiry and continues to advocate a position after learning or having reason to learn that it lacks support, right? And there's Worldwide Primates, Inc. That could be the new company for Jeremy. He could be a worldwide primate. Or, you know what? I think the better one would be Worldwide Reptiles. Because the man does love alligators and crocodiles and iguanas and lizards. He's a lizard lover. And, if we end up going to discovery, we're going to go very, very deeply into how deep he's gotten into lizards. So that's going to be something we'll talk about. So if Exhibit A does not depict Jeremy Hales engaging in oral sex with a journalist, then the allegations in ECF number 189, and then repeated on May 28, 2026 advocacy in ECF number 202 are not fair characterizations or debatable inferences. Is this a debate? Really, honestly, we've seen the video. Do you think that there's a debate here? Do we think that there's some type of, debate as to what this video is? Do I need to play it again? If people think I need to play it again, if somebody wants to get another look to try to, to figure out if this is something that's debatable, let me know, because it's already a court exhibit. It is Exhibit A in the court, okay, of this motion, 2005-1, in the ECF, in Hales versus Preston and Luthmann. It is a court exhibit. That's for Piglet's benefit. Piglet, you know that it's in the court. You can oink your way down there. You can get a copy of it. So, they are false. They are false factual descriptions of the very exhibit on which count 2 depends. That's true. At a minimum, that discrepancy requires Hales and Shochet to explain: A, whether they personally reviewed the exact media before filing, B, what frame, still image, or timestamp they contend supports the allegation, C, why the allegation was repeated after defendant challenged the statutory and factual premise, and D, whether they can maintain the allegation consistent with Rule 11, right? As to counsel, the challenge conduct also supports relief under 28 U.S.C. 1927. 1927 authorized relief against an attorney who unreasonably and vexatiously multiplies proceedings. Wait a second. Multiplication of proceedings. There is a term. I don't know if anybody's ever heard of the term. It's a term of art, and it was coined by a man named Bruce Manskin. That term is called polymop, protraction of litigation and multiplication of proceedings. And if you are an attorney who unreasonably and vexatiously multiplies proceedings, you have a problem in the 11th Circuit. So you're engaged in polymop. That's a problem. That is a big, big problem. It's a huge problem for Randy Pocket Rocket Shochet. So the 11th Circuit requires conduct tantamount to bad faith, including knowingly or recklessly pursuing a frivolous position. And we're going to show that it is knowingly. He knew what he was doing. Here, the challenge factual description was not peripheral. It was used to frame the opposition's opening paragraph, right? The opening paragraph, hold them accountable, to support count 2 statutory theory and to resist dismissal. If the description is false, then repeating it in the operative complaint and again in the May 28th opposition multiplied the proceedings around a non-existent visual premise and forced defendant and the court to address a manufactured factual issue. The court has separate disciplinary authority under Local Rule 11.1G. And so the Northern District of Florida Local Rule requires attorneys in the district to comply with the rules of professional conduct incorporated from the rules regulating the Florida Bar. Local Rule 11.1G authorized discipline after notice and opportunity to be heard. A knowingly false statement of material fact to a tribunal or a failure to correct one raises an obvious candor issue under those standards. If the court finds the challenge description false, it may require an explanation from counsel and determine whether additional discipline, restriction, or referral is warranted. My conclusion. This motion presents a narrow, objective issue that the court can resolve by examining the exhibit itself. Defendant respectfully requests the court require plaintiff Jeremy Hales and counsel Randall Mark Shochet to show cause why sanctions, corrective action, and other relief should not issue if the challenged media does not depict the conduct they repeatedly told this court it depicts. And there's me, Richard A. Luthmann Jr., and there's my certificate of word count and the certificate of service. And here we go. I made my declaration. This is what when I tell the court what's really going on. And so we basically been through a lot of this stuff. I talked about the third amended complaint, and this is where everything is. And we talk about the photograph and engaging in oral sex with a journalist. Okay, and I say it right here. I reviewed the plaintiff's May 28th response in opposition to my motion to dismiss. I published a sexually explicit video depicting plaintiff Jeremy Hales engaging in oral sex with a journalist. I say it right here. That statement is false. That's the legal equivalent of me calling Jeremy Hales a liar. Liar, liar, pants on fire. Jeremy Hales, you are a liar, liar, pants on fire. That's what I just did. I just did that in legal pleadings. I called you a liar, liar, pants on fire. And then Michelle said, he goes, right, polymop, Michelle. That's a good word. It's a $5 word. It might even be an $8 word or a $10 word. That's how good of a word it is, polymop. Bruce did himself when he came up with that. And then we got, what else did Michelle say? They have perjured themselves on every case they have filed. Oh, baby, we're going to get into that in a second. I have even more. We're going to have some fun in a couple of minutes. There's going to be some more fun coming up. And so I basically called him right there. That statement is false. It doesn't get more, to the point than that. A sexually explicit video depicting Jeremy B. Hales engaging in oral sex with a journalist. That statement is false. So it's either I'm right and that statement is false, or Jeremy Hales is right and that statement is true. And I don't think that Jeremy's going to be able to show that that video depicts anything other than satire. Okay? Let's see. The public media identified in the operative pleading does not depict Jeremy Hales engaging in oral sex with a journalist. I think we agree. Public media does not show Jeremy Hales engaged in oral sex with anyone. I think that's true. The public media does not contain an actual video recording of Jeremy Hales engaging in sexual conduct. I think that's true too. The public media does not contain an actual private, intimate image, private sexual recording, or private sexually explicit video of Jeremy Hales that was provided to me by Hales, entrusted to me by Hales, or obtained by me from Hales. So Jeremy Hales never gave me that video. That wasn't a video that was sitting in his safe, like in the Hulk Hogan, the Gawker case, Hulk Hogan versus Gawker, where they broke into his safe and they took a video of him having, intimate video of him having sex. I didn't break into his house in Ohio or in Otter Creek or anywhere else, or I didn't steal that out of his, the dashboard of his car. It wasn't lying around. I didn't grab it. It doesn't exist because I created it. It's satire. It's satire, guy. I did not receive from Jeremy Hales any private sexually explicit image or video of himself. Jeremy Hales never entrusted me any private intimate image subject to any expectation of confidentiality or privacy. To the extent plaintiff complains about edited, satirical, composite, manipulated, or otherwise altered media, that is not the same thing as an actual video depicting Hales engaging in oral sex with a journalist. And that's the point here. He's like, well, he put a Hitler mustache on me, and then he did this, and then he did that. Well, that's fine. You could say that, but that doesn't say anything about the statute. The statute is a revenge porn statute, right? That you were engaged in oral sex with a journalist, that it was an actual video, that I got it, you had a reasonable expectation of privacy in it, and I published it. You're not proving anything here. It's a pack of lies. You're the king of the lies, Germ. That's what you are. Plaintiff's statement that the challenge media depicts him engaging in oral sex with a journalist is not a fair characterization of the media. What do the people think about this? What does everybody think about this? Do you think that this is a fair characterization that what he said? We've all seen the video. I'll play it again in a little bit, but it's not a fair characterization of the media. Not at all. And that's the problem that Randy Shochet's going to run into, because he's the one that's supposed to put the brakes on this. Germ can be stupid. He has a constitutional right to be a fucking moron, and he lives up to that every second. He's a total moron. He's like, he calls me paint chips, but I might be the guy that had the paint chips and it didn't have any effect, and it probably hit his brain because he's a really, really stupid person. Like the fact that he would think that this would be some type of issue. But the problem is that this falls on the feet of Shochet, because it's not a fair characterization. And when it's not a fair characterization, that doesn't show good faith by the attorney. That shows bad faith by the attorney, right? And these next things really hurt Randy Shochet too. The plaintiff's statement is not a debatable inference from the media. Can we debate whether or not that depicts oral sex? No, because there's no frame there that shows that there's oral sex that's happening. There's nothing there that shows Jeremy Hales engaged in intimate sexual relationships. It's just not there. Plaintiff's statement is not merely argument, rhetoric, opinion, or adequacy. That's true. It's a factual statement. It's not argument, rhetoric, opinion, or adequacy. It is a statement of truth or falsity. Plaintiff's statement is an actual false factual assertion about what the media actually depicts. The false factual assertion is material because count 2 depends on the alleged existence and publication of a sexually explicit image or video of Jeremy Hales. That's not a sexually explicit image or video of Jeremy Hales. I don't care what he says. It's not a picture of him. I didn't get that from him. He did not engage in sex in the back of that car. That's the point. I made the video. If he thinks that he did, then he's out of his friggin' mind. This false factual assertion is also made material because plaintiff uses to oppose dismissal, to justify continued proceedings against me, to support his damages theory, and to portray my challenge publication as sexual cyber harassment rather than protected commentary, satire, parody, and or political journalistic expression. I have prepared a thumb drive containing the public media identified in the operative pleading and in plaintiff's May 28th opposition. The thumb drive is submitted as Exhibit 8 to my motion for order to close. Now, these paragraphs are important because evidentially, by doing this declaration, I have authenticated this video for the court. Now it's evidence. It's evidence based upon my declaration. Exhibit A contains the digital media file corresponding to the challenge publication. The file is named Exhibit A Challenge Publication Video. Exhibit A is not submitted under seal. The publication is already public, is specifically identified by URL in the operative pleading, and is central to plaintiff's claim against me. So if he turns around and he tries to seal the this video at this point, because that's one move that the Randy Shochet might try to do, seal the video. They've identified the video in they've identified the video already. They've identified it in their pleadings. And it gets into a very, very dicey area called prior restraint. It's something that's already public. It's a prior restraint for them to seal it at this point. What the judge would have to do if they do a sealing motion is actually view the video. That's what I want the judge to do. So I kind of hope they do a sealing motion. I submit Exhibit A so the court may review the actual media directly and determine whether plaintiff and counsel accurately represented what the media depicts. I respectfully submit the court does not need to accept plaintiff's characterization of the media. The court can inspect Exhibit A itself. I have reviewed Exhibit A in its entirety. Based on my review, Exhibit A does not pick Jeremy Hales engaging in oral sex with a journalist. Based on my review, Exhibit A does not pick Jeremy Hales engaging in actual sexual conduct. Based on my review, Exhibit A does not contain any actual private sexually explicit image or video of Jeremy Hales. Plaintiff and counsel repeatedly place this alleged depiction at the center of their filings and claims against me. Think about that. This is what they've done. It doesn't say it. I lay it out in very clear terms. They didn't do anything it doesn't say it. They've lied. They are liars. That's what these people are. So let's see. What else? Oh, Helen's here. Hello, Helen. Then you get the notification. That's not good. Well, you know, we've had problems all day with this. I don't know what it is. This is Florida. Florida is crazy in the summertime. I don't know if it was the rain. I had a bunch of rain down here. Maybe lightning. I don't know what it was. But it knocked out. I have the Xfinity, which is Comcast. It knocked it out. So, you know, that's what happened before when I tried to have beard done. But we'll try to get him on tomorrow or the next day or next week. Plaintiff and counsel have used the alleged depiction to argue count 2 states a claim, right? They used it to oppose my motion to dismiss, to accuse me of publishing sexual cyber harassment. That's what they say, that I'm a cyber harasser. A depiction to accuse me of committing a crime under the laws of the state of Florida. Because if I was publishing sexual cyber harassment, they have accused me of committing a crime under the laws of the state of Florida. Ooh, what does that do? That's the most important paragraph in this whole thing. Why? Because that opens up all my counterclaims against them. Or my actual, you know, claims. If this case gets dismissed, I can sue them, because when you accuse somebody of committing a crime, the court dismisses it, right? Then you don't have litigation privilege at that point anymore. And then you have actually something resolved to actual slander or libel or defamation. So I have a claim. As soon as this case gets dismissed, right, for failure to state a claim, I get to sue them. I get to sue them all, sue everybody. Plaintiff and counsel have used the alleged depiction to seek damages, injunctive relief, attorney's fees, continuing federal litigation against me. Court should require Hales and Shochet to show cause why sanctions, corrective relief fees, costs, and other appropriate remedies should not issue for presenting and maintaining a false statement of material fact concerning what the challenged media actually depicts. I further believe the false statement should be corrected before this litigation proceeds further, because the statement goes to the factual foundation of count 2. I am filing or lodging Exhibit A with the clerk as a physical digital exhibit, because the file cannot be meaningfully reduced to a paper exhibit without losing the full context of the publication. I am also serving a duplicate copy on plaintiff's counsel with the motion papers. I sent him a copy of that through email, and he's going to get a copy of the motion paper. He got one already through the ECF. Reserve the right to supplement the declaration if plaintiff or counsel disputes the authenticity, contents, format, filing, or public nature of Exhibit A. My meet to confer is on Exhibit B. And so here's what we're going to show everybody. Here's what Megan's going to start crying. Megan, don't cry here. See, look at this. Exhibit A, digital media exhibit. Look at that. 2051. This is the one. This is where it is. This is what made this whole thing public. This is now a public document. And I think Marla's right. Isn't that defamation per se? I think it is defamation per se. I think it's put in the defamation per se category when someone falsely accuses you of a crime. And so I'm going to have a damn good lawsuit against these people. So, and the best part is, if this case gets dismissed, right, then the lawsuit is done, and I can turn around and I can sue them down in the Middle District of Florida. I can sue them out of Fort Myers Federal Court, because Hales is an Ohio person. He's an Ohio resident. So we have diversity, and he's not going to be up there in the Northern District of Florida he's going to be in the Middle District in my home turf. You know, I'm in right by Fort Myers. You know, that's where I am in Southwest Florida. Beautiful, beautiful Southwest Florida. And then Shochet lives in Florida, so he'll probably get sued under a separate lawsuit. Potentially, I bring it in Fort Myers, or I bring it in, you know, down here Naples or wherever in state court in the 20th Judicial Circuit, and so he'll get sued on that one too. And it'll be witnesses in both cases, so it'll be fun. It'll be two separate cases. It'll be a fun one. Okay, what are we doing here? Exhibit A. This is what was making Piglet cry. Piglet is going to cry because of this. Exhibit A is the thumb drive containing the public digital media file identified in the operative pleading of the challenge video publication allegedly posted by defendant Richard A. Luthmann Jr. at luthmann.substack.com. Okay. The file is named Exhibit A, challenge publication video MP4. Exhibit A is submitted so the court may review the actual media directly. Defendant contends the media does not depict plaintiff Jeremy Hales engaging in oral sex with a journalist, does not depict Hales engaging in actual sexual conduct, and does not contain any private, sexually explicit image or video of Hales. Right? So that's what we got. This is now, it's an exhibit. Now it gets even better, people. It gets so much better. I put it inside an envelope, right? So this is the actual picture. I'll pull out. That's the actual picture of the envelope that I put it in, and I put the thumb drive. Exhibit A is the thumb drive containing the public digital media file identifying the opera pleading, the challenge video publication. Well, so why is it written like this by me? Because if we get to court and there's a hearing and I need to authenticate that this is the actual thing, I said, well, that's my handwriting. I can authenticate my handwriting. There's the back of the envelope, right? Look, there's the thumb drive, right? That's the front. That's the back of the thumb drive. This is sitting up in the court. Piglet, this is in the court right now. Look, we'll get nice and close to this for her. Piglet, that's where it is. It's right there, Memorex. See, look at that. That is sitting in the courthouse, Piglet. It's in the clerk's office in the courthouse. It contains the file. It's a filed court document, Piglet. That's what it is. Read it and weep. Cry all you want to all you the retards that follow you, right, on social media. Cry all you want about how it was banned and this and that. It's a filed court document, you effing moron. You are a retard. It's just so sad. Because once it's a filed court document, there's nothing you can say about it. What are you going to say? Oh, no, it's not a court document. It's right here. It's in the court document. It's a filed stamped court document. Call up the clerk. You can get a copy of it. You can pay. I think you pay the clerk and they'll send it over to you. It's like, it is what it is. So, I know, she's such a stupid person. She really is. She's a hideous person, too. She's hideous on the inside more than anything else. She's a hideous, hideous person. And then here's Pocket Rocket. This is what we did. We did our meet and confer. I sent this to him, and I said, "Look, you know, guy, let's do this. I want you to, you know, I'm going to put this in." I didn't get a response to this either. I gave him a chance before I went for the death knell. I will agree to cure the issue without motion practice by doing the following: withdraw the statement that the challenge media depicts Jeremy Hales engaging in oral sex with a journalist. File a corrected notice or amended response clarifying that plaintiff does not contend the actual media literally depicts Hales engaging in oral sex with a journalist. Withdraw or amend any portion of count 2 and related briefing that depends on that factual characterization. Agree that the court may review the actual public media as a physical digital exhibit if the issue remains disputed, and state whether plaintiff and counsel oppose defendant's request for an order requiring plaintiff and counsel to show cause why sanctions, corrective relief, fees, costs, and other appropriate remedies should not issue under Federal Rule 11. And the court's inherent authority, and counsel's duty of candor, and other applicable conduct rules. And so I asked him, I didn't do anything wrong here. I tried to do everything right by this guy. I really don't, you know, and that's the thing. I gave this guy every opportunity to withdraw, to pull out, to do anything, and he's not doing it. And that's the problem. That's the problem with this guy. And so before we go any further, I think that we have to, you know, give everybody one more look at this newly filed exhibit in Fed 2. This is the newly filed exhibit, Fed 2, 205-1, Exhibit A to the motion. It's a filed court document. So I think everybody needs to take a look at this. It's a filed court document.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you take
What do you have in your mouth? What is that?
So that, ladies and gentlemen, is a filed court document. Lisa, she says that Shochet's going to be very busy. Well, good for him. You know, I think he should bill the shit out of Jeremy for all the work he's going to have to do now. I think it's going to be fun. I'm looking forward to potentially going up to the Gainesville court. I really want to go up there and just, see what's going on up there. I haven't been to Gainesville in a while. I think I was there for a football game a while ago, but I haven't been there in years. And it's a decent town. I got a lot of friends that went to the University of Florida that love, Gainesville, love that place. I can take it or leave it. I went to the University of Miami. I got my master's, one of my advanced degrees from the University of Miami. So I'm a Canes fan. I'm a Hurricane. So, I don't have the love for the swamp that some other people do. But I'm a Floridian now. I've been a Floridian now for over half a decade. And, I got love for Florida. So I got to have some solidarity with the swamp people against the Ohio carpetbagger, right? The Ohio carpetbagger is coming down, the Buckeye, from the godforsaken Ohio Buckeyes, and he's coming and he's challenging the Floridians. That's what this man is doing. He's using the federal courts, and when you think about how messed up this is, I'm going to make this point, then I'm going to move on to another piece that we have to talk about tonight. But the fact is that it's tough down here in Florida. Everybody that's in Florida knows how tough it is. Sometimes when you get a bad year with hurricanes, and I know people that have lost everything in hurricanes, and it takes you years to get your shit back together. And a lot of it times you're fighting insurance companies, you're in court, you're doing this, you're doing that, and it takes you a while to get what you need. And what Jeremy's doing is he's carpetbagging down from Ohio and clogging up the Florida courts and clogging up these judges from giving help to the people who need it, who live in the state of Florida. And I think that's the biggest crime we have going on here. Jeremy's a liar. He's probably perjured himself 1,000 times. So is Shochet. But the biggest crime they have going on here is they're sucking the resources and they're taking the food out of the mouths of the children in the state of Florida because the court can't get to getting the checks cut, right? The checks cut. That's what it is. When you go to court, you want to get a check cut. And how many kids out there are waiting to get a check cut? How many families are waiting to get a check cut? And the only way they get the check cut is that if the judge gets to an order that says, okay, yep, you got to cut that check. And this bullshit case, because that's what it is in plain English, this bullshit case, it doesn't have any legs, it's not going to go anywhere, it's really BS. And if it does go to discovery, I'm going to have a lot of fun with it. I'm going to have a counterclaim. I'm going to have third parties come in. Their whole media ecosystem is going to be defendants, third-party defendants that I'm going to bring in. I'm going to turn it into what he tried to do in the beginning, and I'm going to do it the right way because I'm not a moron like Randy Shochet and Jeremy Hales. But I don't want to do that if I don't have to because I don't want to clog the court up either. I feel bad if I have to clog the court up because I don't want that little kid out there to not get the check cut. I want that kid wearing old sneakers with holes in them when he should be wearing new Nikes. And that's really how I feel. That's really how I feel. And I really wish that Judge Bolitho felt that way too. Because if he thought that judge's time was extraordinary, then he would have said, let the reply in and let's decide this motion and everything else. I think the judges do have extraordinary value of their time because they do extraordinary things. And they do extraordinary things when they save people's lives. And when you cut the check, a lot of times you save people's lives. Sign the order to cut the check, everybody's happy. All right, enough of that. Enough of my diatribe. But I want to get in, and we'll show people. This is Randy Pocket Rocket Shochet. He's about as charming as a serial killer. That's what he looks like. That's him in his office. Like, I don't know who's that behind. It looks like he's got the Ayatollah up there. I have no fucking idea. But that's him at his office. And, I have on good authority that there may or may not be weed in his top drawer. Anyway, that's him. And who else do we have in this case? Do we need to show people? Let's see. We showed you the breadsticks. Everybody knows the breadsticks, right? That's the breadsticks. And that's where Megan is headed, the breadsticks. That is what she knows. That's what she loves. That's her raison d'etre. That's why she lives, for the breadsticks. Here's the car, everybody in the back of the car. There may be more people in the back of this car. The car was a lot of people on that car with the breadsticks. So we got to see who the journalist was that we're talking about. My money says it's Don Lemon. Don Lemon, the former CNN journalist, the independent journalist, right? And we'll see. We'll see what's going on there. We also got the issue of Federal Prison Monthly. Paint Chips Rocks the Conjugals. I hear that there's a copy of Federal Prison Monthly with Robbie Kesey on the cover. I do. I heard about that. I haven't seen it yet, but the rumor has it that it's out there someplace. So we have to find that maybe. And then finally, the last picture I'll show is Paint Chips on the beach. That's a good picture I have. That's a picture we're going to have. I'm going to put that in one of my motions coming up. If this thing keeps on going, Paint Chips on the beach is going to have to be a part of this case. It's going to have to get into the public record. I think Paint Chips on the beach is something that is an important point of note. So that's what we have to do. Paint Chips on the beach. I think that's what maybe we'll do that. Maybe we'll do a Speedo contest, me and Germ. If we end up having to do this case, have to go to trial by combat, we'll do combat and Speedo combat. How we do a trial by combat and Speedo? I would do that very, very easily. All right. Now, ladies and gentlemen, I have something very important to tell everybody. Lisa Lee, who's here, and Leslie Ferderigos have been filing motions, not filing motion, sending notices, and Leslie actually filed a motion telling Randy Shochet and Jeremy Hales what despicable liars they are. And I'm going to show everybody some of those notices and motions today, along with a very special video that was prepared that details in living color all of the lies that Jeremy Hales has said. And this is a good video. So for the audience, have you ever seen Jeremy Hales on his show complain about how much money he spends and he's spent on his lawyer's fees? Have we seen that? He goes on and he says it's this amount of money. He just paid $25,000. He just paid $30,000. It's up to $300,000. It's up to $1 million. It's up to $500,000. It's all these different numbers. And so what we have is, and why this is important to Rich Luthmann, is I just asked for an order to show cause, or asked for a show cause order that I get to go and potentially have the two of them, Shochet and Hales, in court with me. And I get to cross-examine them. And I can cross-examine them on their truthfulness. Well, when you tell your audience, when you tell, over 1 million people on all platforms, okay, how much money you're paying your lawyer, and it's one number on day one, and it's another number on day two, and another number on day three, and those numbers don't add up, that becomes something you can bring in cross-examination. And so without further ado, I'm just going to play the video, and then we're going to come back and we'll talk about some of the skullduggery that's behind it.
$390,000 right now. $390,000. We have yet to be in a courtroom to receive an actual decision and judgment, but I can clearly tell you, for all of these freaks and fools, these individuals who continue to break the law, they will be held accountable in the court of law. And it's so profitable that that our legal fees right now are at $408,500. Of these freaks that wish that they had our garbage. Nobody in their right mind would ever believe this outlandish story of our lives. It's going to be a whole lot more. You can pay for that video yourself. And just so we're clear, as of today, because there's quite a few that were like, I can't believe you would make us pay for that video. We are at $436,500 in legal fees. Let that sink in. And for any of you to complain and cry and say, we didn't show you that video. We are at $436,500 in legal fees. We have not even stepped foot in the court and gotten a hearing yet. We have lost because of these freaks. I don't mind telling you, even though it's going to blow your mind. We have lost $1.5 million this past year because of them. $1.5 million that they're going to be held responsible for. And not only last
looks
year,
really happy too.
and the next year, and the next year, as all that grows. And that we can't even get into we don't even know what they destroyed yet on Whatnot, what we could have done on Whatnot because of their sending them the bucks, $1 at a time. And then Liz goes on to say, hope you both have a safe and awesome holiday season. Excited to see how all the drama works out soon. Team Hales. As cool as both of you are, love and prayers, Liz. Thank you so much, Liz. We appreciate you. We appreciate you. Unfortunately, Jay, it's not real money. It's not real money because out of pocket, as of right now, I've paid out of pocket $438,000 in legal fees. $438,000. And these freaks are being sued for $9.5 million in Fed 2 plus damages. And Lynette and Crook are being sued for damages. Levy County is now being sued for infringing upon our civil rights and breaking state law and federal law. It's not a joke. It's horrific. No. It's horrific. And all these paid harassers, not okay either. But
that are recruited by the PR team.
Justice will happen. Justice is slow. And you mentioned ugly. We're going to transition right into the uglies. By the way, if anybody's wondering, what's our total on legal fees? We are still at $440,500. We have not had any bills come in since the last time we shared that as far as legal fees. Yeah. Though we do have court here. And
legal fees, that's a Freudian slip.
That as well. So
it's okay. It's okay. I think I'm okay with that.
I have to cancel it. We are now at $471,500 in legal fees. By the end of this month, we will be at $500,000. I have to cancel Christmas.
Well, you got to do what you got to do.
Well, right now, what I got to do is get this thing to.
I think those are all the names that I have.
Incredible people. Yes. And to take a serious moment and to say truly thank you, not only to Star and to Shizzy and to Megan Fox and to so many others, and those that George just acknowledged. Our legal fees as of today is now at $481,500. And so that goes a tremendous long way, and we appreciate you. We really do. So stupid. There's no way we could fight this battle without all of your support. And keeping these people accountable to the garbage, the literal illegal garbage they have done. And hopefully us fighting on everybody's behalf makes it stop. Now, those people have to choose to make it stop. But
a total of 85 times.
Wow.
How many weeks is that, you guys? 85 weeks. Like how? Help me out. I can't do math.
52 weeks in a year. We've been doing Whatnot for about a year and a half now. So a year and a half. Now,
yes,
all of the funds, I'm going to take, usually George and I are joking. We love humor, but all of the funds are going to our legal fees. We are just shy of $500,000 right now. We are at $487,500 in legal fees to date. what we've been charged and have paid.
Yeah, and that is a
So-
gross amount to me, disgusting amount. And we could have used those funds on legitimate charities.
We could have had Christmas in the Creek.
Whoa,
again.
legitimate
Our lives were
charities?
threatened.
Correct.
And if Levy County Sheriff would actually do
Oh,
their
that
job
sounds
and
like tax
act
fraud.
the way that they're supposed to do, we could have been a blessing with all of your help. We could have been a blessing to this community,
Yeah.
to the kids. We could have sent more backpacks to orphans in
Yeah.
Egypt. We could have helped other Christian camps as we've done in the past. We could have helped
Yeah.
Cedar Key from all the devastation that's
From the
happened.
hurricane.
There's
Yeah.
so many things that we could have done, that we should have done, that we would have done if it wasn't for these sick, deranged, unhinged individuals.
Yes,
they will
unpredictable,
pay.
dangerous
pay.
people that have inserted themselves into our lives in a malicious way.
Yeah.
They only care about charity for the
Delight in it.
Ooh,
Hey now, we're testing it live. This is so awesome.
cool.
And sold to Michelle. Michelle, you got it for 90.
All right, at the request of Nick Ricada, the Godfather's Law Tube. The Godfather.
Nick Ricada, oh my God.
No.
That guy's
This
a
is
scumbag.
the deposition tie that Randy Shochet wore during Lynette Preston's deposition. This is fine Italian quality. Randy dropped it off personally here at the schoolhouse. He said, you know what? I heard somebody is interested in that tie. I want you to auction
That
it
may
off.
be one of the
I want you to
ugliest
auction
ties
it
I've
off.
ever
Now,
seen in my
we are
life.
just under $500,000
I wore that tie, it
right
would be
now
hung-
in legal
It'll
fees.
be
to get
tied
these
to
freaks
a
to
tree
stop.
branch. I'd be hanging
So,
myself.
This
I'd kill
tie is
myself
going to
like
go a
I thought I
long
was.
way.
Hell out of
Is
here.
Nick in the chat? Nick better be in here. This is his request,
For his proxy.
but you don't have to let him win it. All right, let's run it. Lot number 22. Lot number 20. And so, which Crook and Lynette will be legally responsible for those fees. And so we are now $2,000 away from $500,000 to keep people from breaking the law. I mean, that's insanity. That's complete and total insanity. And all they had to do, stop.
Mm-hmm.
Just stop.
Yep.
So that's where we are with this. Let's pull this down. I think there was a couple in the very beginning that we didn't see, but that's like basically, they keep on going on that stuff about all this money. And so they've made these public statements about how much money that's been spent. And so now we got a situation where they may have gotten themselves into a little bit of trouble. And so I'm going to show everybody what we got. Let's see what we got here. We're going to show everybody. Let's see. And here we go. All right. This is the motion we just had up. And so this is what Lisa put in. And the formal notice of client misconduct, out of court defamatory conduct. I'm going to go through this real quick. This is part of what Lisa sent about these people and what they've done. And as a formal written notice, Jeremy Hales, Martha George Risk, Megan Melissa Fox, Matthew Stephen Lewis are acting each defamatory, harassing, intimidating conduct directed at me, other private citizens, including defense in the litigation outside the courtroom. During the pendency litigation, you served as counsel. And you talk all about this, defamatory statements, characterizations, a man, a felon, drug user, fraud, blah, 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 all this stuff that they said. They said such bullshit, and there's no basis for it at all. And Lisa told them, you're a licensed attorney. And so this is the basis, and I know Lisa will probably talk about this a little more too, but they're going to the Florida bar with this, right? They're going to put this into the public record. And everybody knows about Shochet, right? Shochet was a dentist in Missouri. And Shochet got thrown out of dentistry in Missouri for billing fraud, Medicaid fraud, and everybody else. And then he went to Arkansas, tried to become a lawyer in Arkansas. The Arkansas bar said, hell you're out of here. You can't become a lawyer in Arkansas. You're a fraudster. And the big reason was that when he got caught, and he got caught with, fraud, Medicaid fraud or billing fraud and dentist fraud, he was suspended from the practice of dentistry and then still practiced dentistry. He was still doing procedures under somebody else's license. And they said that that's no good. So he went to Arkansas. They said no. But then he went to Florida 5 years later and said, oh, yeah, come on down, boy. And so there's been some case law in Florida where the judges have referred him to the bar. He's been a shitbrick in Florida. So Shochet's got a problem here, I think. And not just with what Lisa put in. And that was a very nice letter that Lisa wrote. But there's also a letter that Leslie wrote on the same day. Formal notice of fraud, Jeremy Hales, Martha Risk, Mr. legal fees to the public involving the instant suit. So what we just showed that video about all the fees, right? And basically, here's the whole point. On multiple occasions, your client, Jeremy Hales, has appeared before his public audience, which consists of substantial online following, has represented public and repeatedly that he's paid you, Randall Shochet, in excess of $500,000 in legal fees in connection with litigation initiated over the past year, including the case I am currently be sued by your clients. These representations have been made during live broadcasts or recorded publications viewed by a large audience. As you are aware, the overwhelming majority of the litigation initiated by Mr. Hales has been found to be without merit and dismissed with prejudice, many of those dismissals occurring at the earliest stages of the proceedings, before substantial discovery, motion practice, or trial preparation could have generated legal fees of the magnitude Mr. Hales has publicly claimed. The GoFundMe campaign. Compounding concern raised above, one of Hales' supporters created a GoFundMe campaign soliciting donations from the public, specifically for Mr. Hales' purported legal fees. That campaign raised $36,721 toward a stated goal of $200,000. The GoFundMe page explicitly states in pertinent part, the Hales legal bills continue to increase and already cost Jeremy and George $539,700 out of pocket, and proceeds to solicit donations from members of the public to assist Mr. Hales in meeting those costs. And here's the picture of that GoFundMe. $36,721 raised. Hello, my name is Debbie Vaughn, blah, 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 blah. These representations made public in connection with an active solicitation of funds are materially false. It is, as a practical and professional matter, next to impossible for legal fees in cases dismissed with prejudice at their earliest stages to legitimately total $539,700. As a retired attorney with direct experience in litigation, I can state without reservation that the figures being represented to the public bear no reasonable relationship to the scope and outcome of the litigation at issue. So, ladies and gentlemen, what is this? This is what's called, it's a very simple word, right? It has 5 letters. Can anybody guess what the word is? We're going to do a contest here. The first person to write, it begins with an F, okay? And there are 5 letters in the word. The first person to write it wins. Can anybody guess what that word is? Oh, Lucinda, you win. That is what it's called. This is called fraud. Fraud. Sylvie got it too. We'll put Sylvie up. So you get second place. Okay, so fraud. Fraud is a good word here because when you intentionally misrepresent something in order to solicit contributions, right? That's fraud. And that's actually, it looks like criminal fraud to me because of the numbers involved. So if you tell somebody, I have cancer and I need you to send me money for my cancer treatment, and they send you $50,000. You have people take money out of their own pockets, and you don't have cancer, and you just pocket the money. That is what's called fraud. People go to jail for that. And what Jeremy and George and the rest of them have done appears to be no different than the person with the fake cancer going to do a GoFundMe and claiming that they need them to send them money, right? So this Debbie Vaughn is a conspirator. Jeremy and George are conspirators based on the money that they claim that was owed, okay? Now, the conduct described includes several provisions of Florida and federal law. Florida Statute 8/1734, the Florida Communications Fraud Act. It's unlawful engaged in a scheme to defraud, defined as systemic, ongoing course of conduct with intent to defraud one or more persons to obtain property for one or more persons by false or fraudulent pretenses, representation of promises, soliciting donations from the public based on material inflated and fabricated legal fees constitutes precisely such a scheme. Well, we saw this, right? Fraud, right? Fraud. And it's a scheme. So he didn't show up and he said his amount that he owed once. He didn't do it twice. He must have done it 10 times, at least 20 times to the people. And they have this site that puts it out there. He puts it on his GoFundMe. So that's fraud. Let's see, Florida Statute 81706. There's more. It's unlawful to solicit or obtain money by property by means of a false or fraudulent representation concerning the need for financial assistance. That's like the person who says they have cancer and they lie. They get $50,000 and then they run away with it. The GoFundMe campaign premised on the representation that Mr. Hales incurred $539,700 in out-of-pocket costs falls squarely within the conduct the statute is designed to prohibit. Additionally, the extent the solicitation were conducted through electronic means, including the internet and online streaming platforms, this conduct may constitute wire fraud under 18 U.S.C. 1343. Wow, that's pretty bad. Wire fraud will get you some federal time. He might be ending up in the federal pen, the little penitentiary. He might go to the camp. He might go to the low, Jeremy Hales. I don't know. But there's a place called Coleman in Florida, which he'll probably end up at if this is actually a federal crime. That's the place that you end up going, in my opinion. He might end up there. Finally, on the Florida Bar Rules of Professional Conduct, especially Rule 4-8.3, an attorney who knows that another person is engaged in fraud has a duty to take appropriate remedial action. I'm placing you on notice. You're fully aware of this conduct and cannot later claim ignorance of it. So they know that there's some fraud going on. So that's an issue. They had some fraud. So what do we got here? We got fraud. I got some good fraud here. Fraud. Yes. Marla has said it too. Fraud. That's the word of the day. The word of the day today is fraud. So let's go back. Let's read some more about counsel of record exposure. Your exposure is counsel of record. And this is Leslie. Leslie writes very nicely. This is very nicely writing. I do not raise these issues lightly or casually. I raise them because the misrepresentations being made to the public are directly tied to your representation of Mr. Hales in the case he has filed against me, and because your name as his attorney of record is central to the credibility of the claims being made. When Mr. Hales tells his audience that he has paid his attorney over $500,000, and when the GoFundMe campaign attributes that figure to out-of-pocket legal costs, the implied representation is that those funds were legitimately paid to and received by you in exchange for legal services rendered. If those representations are false, you have an obligation to address them with your clients, Jeremy Hales and Martha George Risk. If they are true, then the billing records will reflect that, and I intend to obtain them during discovery in the case in support of the countersuit I intend to file. Pending litigation, pending discovery. As you are aware, I am currently part of the active litigation in which you represent the opposing side. Following the hearing on the pending motion to dismiss, I intend to file a counterclaim. In connection with the counterclaim and the broader issues, I intend to seek full discovery of all funds received by you or your firm from Mr. Hales for any third parties on his behalf and any other sources related to his legal fees, including but not limited to any funds traceable to the GoFundMe campaign and other public solicitations. I will seek a full accounting of all billing records, retainer agreement, trust records, trust account records, and payment receipts. That's the big one. See the trust account records? That's how you get the lawyers. Like if the lawyer's been messing around with their trust accounts, something like this could destroy Shock. That's the easiest way to get you. Like a lawyer could kill their client and still probably keep their license, right? But you rob a client, you play around with your trust accounts, it's all over. So that's what we got. What does we got here? Megan will show a body cam of Robbie on Rumble when his alarm went off at his warehouse just to harass. That's true that they did that. They've done some crazy stuff, those guys. And they're going to be held accountable. Don't worry. Everything's going to happen here. And when the feds roll in on something, or even law enforcement in Florida, like Luthmann don't like German and doesn't like Shochet. They don't like the case against Dan Owen. That was the Florida Attorney General had to do that. So they're not making friends with the people in Florida that are the important people who, keep happy. When you're pissing off the Attorney General, it's not going to end well for you. Please find a copy of this letter along with supporting documentation will be submitted to the Florida Bar to accompany a formal bar complaint. Florida Bar will be asked to investigate whether the public representation made by your client, representation that directly involve your name, your fees, and your legal services, constitute conduct that implicate your obligation under the rules of professional conduct, including but not limited to Rule 4-8.4, prohibiting conduct involving dishonesty, fraud, deceit, misrepresentation, and Rule 4-1.2, governing the scope of representation, a lawyer's duty with respect to a client's conduct. His letter is not sent in anger or tactical maneuver. It's sent because the conduct described herein is serious and fraudulent, ongoing, directly affects members of the public who are being solicited for money based on what appears to be materially false representation. That's the key. The key of what the bar has to do is protect the public, right? And if you have attorney predators out there, you have predators that like people that pretend they have cancer and they don't, and they take money from people, or people that pretend they have legal fees and they don't take money from people. You got to stop those predators, and you have to stop the attorney predators that enable them. And that's part of the issue here. So you have an obligation as an officer of the court, a member of the Florida Bar, to address this matter with your client without delay. Go govern yourself accordingly. So that's what Leslie said about that. So that was a nice little article, not an article, but a notice that she wrote there. And so then finally, the best part about this whole thing is the last little piece that I'm going to show. Because it's already getting close to 1 o'clock on the East Coast. This was a filed court document. Everybody see this piece of paper? It's already 1 o'clock, so it's the 4th right now. But this was filed yesterday now. We started, it was the 3rd when we started this live, but now it's the 4th. But this was filed just less than 12 hours ago, actually, at 3:02:03 p.m. in the Circuit Court of the 9th Judicial Circuit for Orange County. Jeremy Hales, Martha Risk, Megan Fox, Matthew Lewis. Plaintiffs versus Michael and Leslie Ferderigos. Supplemental motion requesting Randy Shochet to be referred to the Florida Bar for unethical conduct. Now comes Leslie Ferderigos, defendant, retired attorney, pro se, pursuant to the Florida Bar Rules of Ethics, requests this court sanction Randall Shochet by referral to the Florida Bar for further investigation as follows. This supplemental motion is being filed to bring about new allegations in support of the motion requesting Randall Shochet to be referred to the Florida Bar for unethical conduct. 6-1, 6-2, 6-3 on the Shochet was served with a notice to advise his clients, Hales, Fox, Lewis, to cease speaking about Ferderigos, making the YouTube channels in front of an audience over 100,000, making false statements and commentary with intent to harass, intimidate, defend Leslie Ferderigos, as a required potential witness. And that's important. She says 100,000 viewers because he says he has 700,000 YouTube viewers plus, and he's got all this other stuff, but he doesn't get a lot of viewers. Like he's been in a lot of trouble lately with the number of people that have been following him, right? I think that people recognize that now. I'll make this a little bigger so it's easy to read. But people who have been watching him, and I think Super Dave did this about a month and a half ago, where he did the analysis of how many people are watching. Yeah, he has half of his audience that he used to have. When he does his lives, he's not getting any viewership anymore. He's like passe. He's over the hill. The guy's pretty much done. And so when he claims that he's got all these viewers, it becomes a question of fact. Does he really have all these viewers or not? Right? Does he have all of these people that watch him? How many of those views are real, and what percentage of the people are actually watching him? The percentage of the audience. What are the numbers? So that becomes an issue. Okay, let's see what we got next. Arizona party. In these letters, Shochet was provided thumbnails and titles of live streams published to his clients, harassment, intimidation. Served the notice of clients. Fraudulent scheme to solicit donations under the guise of legal fees for cases that Randall Shochet has represented them over the past 2 years. The majority of the cases Shochet represented plaintiff, Hales, and Risk were dismissed with prejudice in the early stage. These cases were initiated by Hales and Risk. Over the last year, Hales and Risk have filed meritless lawsuits that were dismissed with prejudice for failure to state a claim while being represented by Shochet. They have used their YouTube platform to falsely depict the status of the case while telling their audience they spent over $1 million in legal fees during these live streams to solicit donations from the audience. Additionally, starting in 2024, plaintiffs Jeremy Hales and Martha George Risk initiated a GoFundMe platform where they direct payments to be made to Shochet, claiming to be out of pocket $539,700 for legal fees, directly payments. That's what we just talked about, right? We just talked about the GoFundMe. And this is a problem for them. Now it's in filed court documents at this point. Like someone could take this document and send this thing directly to the FBI. This sent us to cyber crimes, and they could investigate this at this point because it's a file court document. So, during Shochet's representation of plaintiff Jeremy Hales, Mr. Shochet was aware his client Jeremy Hales has publicly published several videos in front of an audience of over 100,000 viewers where he brags about filing lawsuits against people for the purpose of bankrupting. That's true. He does that. We've seen that before. Plaintiff Jeremy Hales monitors YouTube live streams. Evidence of the inconsistencies of what they told their audience of legal fees. On June 1st, 2025, Jeremy Hales tells an audience of 60,198 that he has paid $960,000 in legal fees. Yeah, we had that there. That was the very first one. I think we might have skipped that. But that's what he told them. 29th, he had 600,000, 60,000 viewers. He's paid $360,000 in legal fees. Right? July 20th, 25, $390 in legal fees. September 7th, $480. 480, $500. September 7th. A week later, $436,500. How the hell do you pay more in legal fees on September 7th than you have on September 14th? Tell me how the hell that happens. Unless you're lying, right? Unless you're lying. Well, I like this. Timothy said something very, very nice. Richard, with all these stupid bastards harassing people on YouTube, shouldn't YouTube share in the liability? Well, I will digress at this point because I was getting a little bit upset about how this guy can say that he owes $485,000. He paid $480,500 in legal fees on September 7th, and then he turns around and he says that he paid $436,500. So I don't think Randy Shochet refunded $45,000 plus in legal fees in a week's time. That just doesn't happen. So Timothy's point is very important because YouTube liability. So this gets into a very important legal concept called Section 230. So Section 230 is the immunity law that keeps the social media companies from being liable in the United States. Right? They're Section 230. They're hosts, and they host the content. They're not responsible for the content that's on their platforms. The people that are responsible for stuff on their platforms, unless, of course, there is a greater hook that brings them into the production of the content or the development of a product. And so you have cases here lately that have said that, you know, there's a theory in law called design defect. And what design defect means is if their algorithm was designed effectively, then their algorithm is a product. Design defect means product defect. And if it's a product defect, then you can sue the hell out of the social media companies. And a couple of those cases worked because of the design defects in the social media notifications, particularly for youth and related to youth suicide. So that is the fertile ground here. If you can say that there's some type of defect in the design of how the social media companies, including YouTube, did their algorithm, and if they knew or should have known that there was harassment or brigading or some of these other things going on with respect to Hales and related accounts, and their algorithm, for some reason, whatever reason, was defective when they come out and they say that they're going to do something and they don't do it, then they got a big problem. And then they got potentially a contractual issue with their terms of service, and they got a design defect because design equals product, and design defect equals product defect equals liability, big time, bigly. So that's a very, very good question. That's a great question, Timothy. That's a very good question. So let's talk about some more of this bullshit right here, because this is like Leslie laid it out perfectly here. It's like, you know, look at this: 436.5, then 438, 440, 471. He talks about all this stuff, and it's like none of this stuff is plausible. 481, 487, then February 8th, right? Okay, it was 487 on February 1st. February 8th, he says, 1 million in legal fees. That's what he tells everybody on the 8th, right? And then 15th, the next week, he's $1,500 away from paying $500,000. The guy's out of his mind. He's like, it's either A, he's not telling the truth, right? And if he's not telling the truth, then he's got a big problem with his GoFundMe, right? Because when he's got that GoFundMe, he's like $2,000 away from $500,000. He's got a big problem with the GoFundMe because he's misrepresenting to the public audience, and so he's got liability there. It's wire fraud potentially on the federal. It's Florida state fraud. He was in Florida when he was doing this for part of the time, so there's Florida jurisdiction, and so this is a very good motion. If you want to read it, it's out there. I'll put it out there as well. I'll probably put it on the website, which is the anti-slap watch. So some of this should go up, but there's a lot of stuff here, and it gets, it's a lot about the bar and everything else. It's good, but there's a lot of good little tidbits if you read it. She put together a bunch of good exhibits, and that's where the fun stuff is. This is where she had here. This is the formal thing we just read. And then what else we got here? We'll go through. Let's see. All right, here we go. This is some of the stuff that we have here. This is Megan Fox, or Piglet. We call her Piglet. Piglet is her name. And this shows who the people are in the Hales conspiracy. That's that umbrella guy, or Tug, right? That's that guy. Okay. Where else do we have? These are all the things you said. Here's another, here's another thing that they put out. She's put them all on notice what they do. See, that umbrella guy, Megan Fox, and this is what they do. They send these different things. This is like very, very good because it has everything that they've done. They can't argue that they didn't receive it. They can't argue that they don't know. She has all these great notices here. And here we go again with the GoFundMe, right? That's in the document. So I don't want to bore everybody with this, but it's a decent document to look at. Now, I'm going to put something up. I want people, I need everybody who's on who hasn't already to subscribe to Luthmann News. So I'm very close to 500 subscribers. And when I get 500 subscribers, I get I get YouTube developer something or other. I don't know what it is. I can do like extra things. So it's going to help me in my battle against the germ. And just subscribe to me. Make sure you subscribe and like and all that other stuff so that I can start battling this guy. Because now I get into the ball game with this guy, because if I can do that, I get to be able to beat him up a little bit better. So he does what he does. They're going to do what they do. And I finally got my sea legs under me with going after them with everything they do with their brigading and their mass complaining and commenting and all that stuff. So I've already dealt with YouTube already. So I'm doing good there. We're trying to get Volpe his YouTube back too. I'm actually making inroads with YouTube executives as we speak. So hopefully, we get Volpe. And what I may do is I may have, if I can get some, thank you, Ray subbed. If I can get some people, maybe, I'll do a live maybe next week or the week, sometime after that, where we talk about, and I'll teach everybody who to send a message to at YouTube so that we can get back Volpe's thing. For guys who people don't know, Volpe's my podcast partner. I do journalism with him. He's a journalist out of Chicago. And the thing with Volpe is Volpe got his YouTube terminated by Hales. What Hales does is they do something called brigading. And what brigading is, and I'll take this stuff down at this point. What brigading is a situation where they go on and the brigade, the Hales brigade, all of them go together and they go and they attack somebody. They figure out, we're going to go attack, we're going to mass report, we're going to do this, we're going to do that, we're going to do the other thing. And the way the YouTube algorithm works is they see this person as a problem. If all these people are going to attack this person, that person must be a problem. And so unless their account is has a notation on it that they're a journalist, or they're EDSA is the thing that they have. It's called educational, documentary, scientific, and artistic. Unless you have that exception that's on your account or accounts, depending on what you have, then you could have your account wrongfully terminated. And that's what they did to Volpe. Volpe's a journalist for many years, and he had his account terminated. That just shouldn't be happening in America. But that's what they don't care. They're fascists, in my opinion. That's what they are. They go in and they have a little cult, and they do what they're going to do. So we have that, and we have this other site too. I want everybody to take a look at this one. I'm going to put this one up in a second too. This is Facebook. There's a group on Facebook, and the Facebook group that we have that is run is the anti-slap watch for Jeremy Hales, and it's named Facebook-groups-Jeremy Hales. Just goes to show that this guy's a retard when it comes to marketing, because you would think that if you're going to have a million followers across all your platforms, you might want to reserve your name on social media. And this idiot didn't even reserve his own name on Facebook. So now we have the Facebook domain that's facebook.com/groups/Jeremy Hales. And what that is used for is the anti-slap watch. And what that anti-slap watch is we basically, and I mean, maybe I'll show this to everybody. Maybe that would be fun to do, actually. Let me show this to everybody. I have it right here. Share screen. Here we go. This is the anti-slap watch on Jeremy Hales. And this is the website. I'm going to show everybody. That's, the pictures here. And what we do is there's a whole bunch of people that enjoy this site. And anybody who wants to join it, usually we let people join. But we have a lot of fun on this site because we don't have the other idiots. There's like another group, there's like 2 or 3 other groups of Jeremy people. And they always ruin everything because they're very, very stupid people. All of Jeremy's people are very, very stupid. So this group doesn't have a lot of the stupid people in it. And I say it right here. I said what this group is. This group is a place to share court filings, dockets, orders, transcripts, and public records. It's a forum for commentary, criticism, analysis, and opinion about a public figure. That's Jeremy Hales. He's the public figure. A place for free discussion of litigation, vexatious litigation patterns, and legal strategy, and a repository for links, screenshots, filings, and timelines that may disappear elsewhere. So you put them up here, and it becomes a part of, permanent public record to a certain extent. So all the stuff that's going to go up, you post it here, you post a video here, you post something else, it ends up here. And so what this group isn't, not a fan club, it's not a harassment group. It's not for threats, doxing, or private information. It's not controlled by Jeremy, his moderators, or his lawyers, right? And there are some very basic things. Free speech, free press, free association, due process, equal protection, right? If it's false, you challenge it. If it's true, you cite it. If it's an opinion, you debate it. Very, very simple. And there's animal rapist Jeremy Hales, alligator me too. So, and that's the question. Is Jeremy Hales an animal rapist? Question mark. And because it's a debate. That's what we do. We debate these things. And these are the many things that we do. So, and there's a lot of good stuff on here. So let's say, like, this is what happened. This Piglet, right? And so this is beautiful because Piglet put this up earlier. And so this is actually the funniest thing I've ever seen. Lisa Lee files false privacy complaints against legally obtained public information, while at the same time posts the sexually disgusting video made by Luthmann that has already been banned from YouTube. This is how you lose your channel. This shows me, in my opinion, a premeditated act of what's called brigading, right? Do we know what brigading is? Brigading is when they get together and they brigade on you. And they come in. Let me see if I get brigading. I can get that up there. Let's see. Definition of brigading. This is, if anybody wants to know what things are. Here we go. Make this nice and big for everybody to see. Share this tab. Here we go. Brigading. Can everybody see brigading? Noun, digital technology. The practice of organizing or participating in a coordinated campaign of online harassment against a targeted individual or group, especially on social media. Female streamers and members or allies of marginalized groups are targeted more often and suffer more persistent brigading on their channels. So that's what this is. This is actually a real thing, brigading, digital technology. This is what they do. They do brigading. And so they get together and they attack, the account. So what I'm saying about this is it looks like it is an admission of brigading. right? And so brigading itself is a harmful conspiracy that they're engaged in. If you're part of the brigade, if you're a member, if we can show that there's a brigade, we can show that the brigade does harmful things, and we can show that specific people each are members of this harmful brigade, we can turn around and we can sue. And that's part of what's going to be the crux of what I do when I do my counterclaim against these people. It's going to be a beautiful, beautiful counterclaim. So, and that's the group. This is the group, facebook.com, group Jeremy Hales. And it has my video from the other day. I did my, I was on Lisa and Robbie, they see me and them. And I talked the other day about where we're going to go with a lot of this stuff. And one of the most important things that people have to understand is that I have very, very special skills. I told this to Lisa. I told this to everybody that was listening the other night. I don't know if anybody's ever seen Harry Potter. Does anybody know the Harry Potter movies and the books? Does anybody know about Harry Potter? Has anybody been to Universal Studios in Orlando and gone to the Wizarding World of Harry Potter? Well, I was at the Wizarding World of Harry Potter, and I recognized and discovered that I have a very, very special skill. And that skill is called parcel tongue. What that means is I can speak to alligators and crocodiles and iguanas and lizards. And there's only very few people that have that skill. There's Salazar Slytherin, who was the founder of the House Slytherin, and then there was Lord Voldemort, and then there was Harry Potter himself. There's only about a few people. Maybe I think that Robbie might have that ability a little bit. He talks to a lot of lizards and reptiles. But in so having this skill, I was speaking to the reptiles. I took their interviews. I took their reports. I interviewed the reptiles, and I found out that Jeremy Hales is an alleged iguana injector, crocodile copulator, lizard lover, and he does things with alligators as well. We all know what he does with the alligators. So I did what I had to do, and I started interviewing the poor reptiles and alligators. And so this is what I'm preparing at this point, and the people should know this. And we talk about this on the Facebook page, how I'm going to be preparing as next friend of the court a lawsuit, a counterclaim. If this case goes and it doesn't get dismissed, I'm going to bring a counterclaim as next friend to all the animals, all the little baby animals, the little baby lizards and iguanas and all the cute little things, and as for all the harm that Jeremy Hales has caused them. We're working on the theory that Jeremy tried to have a freak out, like a P. Diddy freak out. And he bought a whole tank full of a tanker, not a tank, but a tanker, like a tanker truck full of baby oil. And he tried to have a freak out in the swamp. And so we're still reconstructing that. We're still investigating that. And we're taking our statements from the people. So that's where we are on that. But I digress. Anyway, so that's where we are on this fun stuff. And then, okay, so that's everything that I had here today. I think we did cover a lot of ground, though. I think we did. Usually I don't go this long. This is 2 hours and 22 minutes, only because we had so much to do. So that's what I have for tonight. And I think that I'm going to sign off in a few minutes. I'll sign off in a little bit. But does anybody have any questions? I've been looking at the chat, and if you have any questions about this stuff, I'm going to be putting this stuff up. Litigation privilege. That's right, litigation privilege. I can talk about all this stuff because it's litigation privilege, and I am looking to investigate the litigation. I'm in litigation with Jeremy Hales at this point, and I'm looking at claims against him that I'm potentially going to bring into the court. That's exactly right, Monica. That's why I'm talking about the iguanas and the lizards and the crocodiles and the alligators, because he sued me under the cyber sex revenge porn statute with no basis whatsoever. I think that I have at least as good a basis, if not stronger of a basis, to sue him under the animal bestiality statute. I really do. And so litigation privilege is exactly what I'm doing. I'm trying to explore all the litigation that I have against him. So litigation privilege is a very important thing because it's related to the claims that I may assert against him in this case. So that's what we're going to be doing. And that's it, right? Lisa, I still have litigation. We got plenty of litigation privilege, Lisa. We got lots of litigation privilege. Lots to go around. So that's where we are. So it's 1:24 right now. So I'm going to sign off in a second. I'm going to just remind everyone the most important development tonight. I'm going to recap it for anybody who might have nodded off. I'm going to show everybody again on the screen. Let's go find this here. It's not this page. It's this page right here. Where is it? It's this page. Here it is. There it is, right there. That is the most important development today, right there. That is the hard drive. That is the thumb drive that's sitting in the courthouse, in the federal courthouse in Gainesville, Florida, with the video that has the alleged plaintiff, Jeremy Hales, having sex with a journalist. And so that is now a filed court document. The video itself is a filed court document, right? And so that's what we needed to show to let everybody know that this is a filed court document. Don't let Piglet bullshit you and let everybody say, oh, no, that shouldn't be on this and that shouldn't be on that. This is here. It's an exhibit. See, Exhibit A, Digital Media Exhibit 1:25CV00058. Ray Hinkle, right? Or Randy Hinkle. I forget whose name is. Royce Hinkle, something Hinkle. And Robert Hinkle, I think it is. Robert, that's it. And Zachary C. Bolitho, document 2051, filed 6/3/2026. Exhibit A, Digital Media Exhibit. Exhibit A is a thumb drive containing the public digital media file identified in the operative pleading. It's a challenge video publication alleged posted by defendant Richard A. Luthmann at luthmann.substack. If you want to go there, luthmann.substack.com, you can always subscribe to my Substack. The file is named Exhibit A, challenge publication video. Exhibit A submitted so the court may review the actual media directly. Defendant contends the media does not depict plaintiff Jeremy Hales engaging in oral sex with a journalist, does not depict Hales engaging in actual sexual conduct, and does not contain any private, sexually explicit image or video of Hales. That's it. That's what we have as the center of the case. And so, ladies and gentlemen, I will bid you all adieu tonight, and I'm going to close with the newly minted exhibit in the court that I just referenced, Exhibit A. So that is going to be what we use on the way out. So thank you, everyone, for coming tonight. And I'm going to go actually try to get some sleep. Have a good night, everybody.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women with good personality and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money. Won't you?
You have in your mouth. What is that?